Board, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. My name is Justice Vicki Henry. I use she, her pronouns. I'm delighted today to be joined on my right by Justice Hershfang, who also uses she, her pronouns, and on my left with Justice Smyth, who uses he, him pronouns. Some housekeeping matters, just so everybody knows what's going to happen this morning. We'll call the first case first, but we're going to call the second and third cases together, and I'll have each defendant argue, and then the Commonwealth will argue. Here in the appeals court, we have 15 minutes per side, for better or for worse. We don't have rebuttal. I think that's everything I was going to cover this morning. So with that, we can begin with the first case, and that is 2023P0547 Commonwealth versus Jeffrey Knight, and I should say today is April 8, 2024.
Good morning. May it please the court, Dennis Toomey on behalf of Jeffrey Knight. We're asking you to please reverse Mr. Knight's convictions, because if he had received a fair trial and effective assistance, the verdicts likely would have been different. This is a case about overwhelming cumulative prejudice from interconnected errors, all of which impact the central issue of the alleged victim's credibility versus Mr. Knight's credibility. Turning first to the issue of the trial prosecutor improperly questioning Mr. Knight, asking him to comment on the credibility of the alleged witness, the alleged victim, and why she would fabricate. That was a clear error, but it caused unfair prejudice, which the trial judge failed to find. It caused prejudice because the trial prosecutor argued it in closing. There was no...
So I'm going to pause you there, and the thing I forgot to say, so we won't take this off your time, is that we've read everything. We say it every week, every time we sit, and it seems like people don't believe us, but we have. So I would encourage people to focus their arguments, and you're focusing yours. But but I'm interrupting you early because the Commonwealth argues that, in fact, the prosecutor wasn't arguing this point in closing, but in fact was, and the trial transcript seemed fairly supportive of the Commonwealth's argument. So could you walk me through what language it was that the Commonwealth used that you thought took unfair advantage of what was definitely an error?
Yes. So in closing, and we addressed this in our reply brief, in closing, the prosecutor urged the jury to consider Mr. Knight's testimony about why the alleged victim would fabricate it, and the prosecutor specifically mentioned this incident in the lunchroom, which was Mr. Knight's answer to the question. The improper question was, so she would have no reason to fabricate anything about you? And the answer was, unless she still held a grudge regarding the 6th grade lunchroom. And that's what the prosecutor asked the jury to focus on.
Didn't the victim also testified about the lunchroom incident, though?
Yes.
So
She brought it up.
if I may pick up Justice Henry's question and run with it, why are you so confident that when the prosecutor in closing referred to the lunchroom incident in order to discard it as motive to lie, that the prosecutor was referring to the testimony of your client on cross and not the testimony of the alleged victim?
Because the prosecutor specifically said, let's talk about Jeffrey Knight's testimony and what he said right before that comment. And again, we don't have to be certain. The question is, what would the jury have thought it to be? And the jury reasonably could have thought that the prosecutor was directing them to Mr. Knight's answer to the improper question. So I don't think we can be confident.
I think it's clear the prosecutor was not supposed to ask this question, but the case that you cite says the question went on for pages and pages and pages, and here it was really a short amount of questioning. Why in that circumstance, and I think even here where the trial judge said they didn't think there was a miscarriage of justice, why should we conclude otherwise?
Yes, I don't think that the number of questions are outcome determinative. I think the focus should be the fact that this was the alleged victim and the key claimed prior bad act witness, MC, who Mr. Knight was improperly questioned about. The way the prosecutor used it in closing, the fact that there was no curative instructions ever. The judge never said to the jury, do not consider Mr. Knight's answers to these improper questions.
And there was no request for a curative instruction either.
That's correct. And that dovetails with our ineffective assistance claim of failing to object and failing to request a limited or curative instruction. But this was the critical issue of trial, whether the alleged victim was telling the truth entirely or whether she was mistaken or misremembering or exaggerating versus Mr. Knight's credibility. This went to the heart of the case.
So as I recall your briefing, you argued this was preserved prejudicial error. Is that correct?
We did. Even though trial counsel failed to contemporaneously object, there was a motion in limine filed that was not granted. So we argue under the Grady case that should be sufficient to
So
preserve.
their Commonwealth's response to that is your motion in limine was limited to the witness FA and it wasn't a general motion. What's your response to that?
I would respectfully disagree, although the motion in limine that trial counsel filed does mention in particular at the end that witness FA. The body of the language says we request that the Commonwealth be prohibited from asking also any defendant witnesses. That would obviously include the defendant. But even if it's not preserved, I think, an error creates a substantial risk of a miscarriage of justice unless you can be sure it did not influence the jury. And I don't think we can have that confidence here, especially when you view that error with the next error, that being the voluminous prior bad acts that came in. There was more claimed prior bad act testimony at this trial than there was testimony about the alleged victim's claims. And that in and of itself should tell you just how bad this trial was. But focusing on the prior bad acts that were admitted without objection regarding claims of alleged threats and violence or threatened physical violence towards male students, which had nothing at all to do with the alleged victim's claims in this case. And that's testimony from BD, MC, and FA. Trial counsel admitted there was no strategic reason for not objecting. The motion judge found that trial counsel should have objected and indicated that the evidence would have been excluded. So this, again, is an issue of prejudice. Knight was really deprived of a substantial ground of defense here because that ground of defense being not having the jury hear all this stuff that really is inflammatory. You don't know him, but reading this, it seems like he's a bad guy, and he's not. But this is really inflammatory stuff that prejudiced the jury. It unfairly bolstered the alleged victim's credibility, and I believe it unfairly made the jury discredit and dislike Mr. Knight. This trial was...
I hear you on the discredit and dislike, but how would testimony about the defendants having been verbally or even physically abusive toward male students bolster the credibility of the victim who was a young woman complaining of alleged sexual abuse?
I think it just comes back to the human nature aspect of it. If the jury doesn't like one party or the other, then they're more likely to side with that party. And I think this has to also be viewed in confluence with the voluminous other prior bad act evidence that we also contest, that being the three other female students whose testimony was admitted, claiming that there were similar acts done. So I think when you combine the prior bad acts of the claimed violence against male students with three other girls claiming that similar incidents happened to them, I think this is a case where the jury really could have substituted saying, hey, we might not have believed the alleged victim but for all this other testimony.
So on the mother being allowed to testify, the Commonwealth argues that her testimony was admissible in its case in chief to anticipate your argument about the school's investigation. What do you say to that?
I respectfully disagree. I think that it was essentially a first complaint violation. Even if she could testify about saying that there was a meeting with the school on a certain date, she's not supposed to testify that this is what my daughter told me. And she did testify that he touched me, I believe was the exact language. That's a first complaint violation that should have been objected to. And it was not necessary to further any avenue into the school's investigation. Third, trial counsel failed to request jury instructions on accident and lesser included simple assault and battery.
So you argue that the defendant conceded an accidental touching could have occurred. argue that in your reply brief, but there was no record citation to that concession. So I was trying to understand where that was in the record.
That was in Mr. Knight's testimony, and I believe that was in our brief. I'm happy to provide this citation in a post-argument letter, but Mr. Knight testified that there could have been accidental contact with his apron and the tape measure that he carries in the lower pocket of the apron that could have caused contact.
I have a cite to transcript 3, pages 163 to 164 from your brief.
Thank you. And so although he's always adamantly denied ever intentionally committing any indecent touching, he did concede that this was a busy classroom. He didn't even remember helping the alleged victim with this incident. And so this is a situation that, you know, quite frankly, any teacher could be in a crowded classroom. Any teacher, whether you're teaching at a public middle school or a makeshift school in the Marshall Islands or a private academy, accidental contact could happen. It was not inconsistent with Mr. Knight's testimony. And if you look at count 4, that was the only count for which an accident instruction was given. And the verdict was not guilty. So I think that is the prejudice here. That is what Mr. Knight was deprived of, a possible acquittal on all charges, especially when you look at the alleged victim's story changing over time. Her initial story did not, even to her mother, did not include a claim of feeling an erect penis. That was added later. Her initial SANE interview, she says about the Lego incident, which is count 3, I guess maybe we did a Lego project once. None of the details from trial were in the SANE interview, which occurred in May 2018, a week or two after this supposed Lego project in March or April 2018. So the weakness in the Commonwealth's case, which is relevant to all of our prejudice arguments, is that her story was inconsistent. It changed
But
over
isn't
time.
that, I mean, I hear you on that, but that's obviously grounds for cross-examination at trial, and those grounds were well traversed in the course of the trial. How is it relevant to the argument you're making now?
Just that one of the factors for this court to consider for prejudice is the strength of the Commonwealth's case. And the Commonwealth's going to stand up here in a minute and say it was overwhelming, and I just respectfully disagree. This was not, the dream alleged victim. This was really an alleged victim whose story changed over time.
I want to ask you a question just briefly about the missing portions of the transcript and the reconstruction efforts, such as they were. With respect to the missing portions of the transcript, which from my read I understand are sidebars, what do you expect they would show? What would the reconstruction accomplish?
Well, hopefully it would have shown whether trial counsel objected any more than the record currently shows. And the most disappointing aspect is trial counsel did not cooperate. We requested an affidavit from them on reconstruction. They did not provide one. I don't know if that's because they learned we had made ineffective assistance claims or not.
Well, they provided an affidavit with respect to the ineffective assistance claims,
they did,
right?
That's why I was flummoxed as to why they would not participate in the reconstruction. But I had hoped if there was an evidentiary hearing on the reconstruction efforts or the motion for new trial that we would have been able to compel testimony just to ask if they had any additional information about the missing sidebars. The trial prosecutor did produce an affidavit about that, but I just don't know if there was any other objections, and that would be relevant to the standard of review for any issue. So that's the real crux of the reconstruction. But the absence of a lesser included instruction as well was arguably ineffective assistance. Simple assault and battery. The sentencing disparities are staggering between indecent assault and simple assault, not just jail time, but sex offender registration. The Lego incident, count 3, there was no allegation of feeling a penis when leaning over. There was just an allegation that his chest or thigh may have touched her back or the top of her buttocks. So the jury could have found that maybe he was standing too close, but that it was unwanted touching but not indecent. There was a rational defense there. The prosecutor, 1 week before trial, told defense counsel and the judge that we were going forward on count 3 only as simple assault and battery, not indecent. Then on the day of trial, she switched back and said, we're going to call this indecent. And that's part of the, my claim of amending the complaint too many times, but just for purposes of lesser included. Even at trial, at the end of trial, the trial prosecutor requested a jury instruction on lesser included assault and battery. And the judge denied that erroneously, we argue, because when one party requests a lesser included offense instruction, the judge must give it if any view of the evidence supports it, even if the other party objects. And that's Commonwealth v. Chase, 453 Mass. 293. So the judge erred by not giving the instruction, but also trial counsel, the decision was manifestly unreasonable to not pursue it. Because it was an available defense, it was not inconsistent with the testimony, and again, because of the sentencing disparities. Fourth, and I would just bring back to Justice Hershfang's comments about impeaching. I don't believe that the trial counsel adequately impeached the alleged victim. In fact, one of our claims of ineffective assistance is failure to impeach with the prior sane interview. So I would just point that out. I can see my time is running short. I just want to say, when you leave the courthouse today, you might see the eclipse. I'd ask you to keep the eclipse imagery in mind, because sometimes there comes a point in the trial when there's too many errors, too many failures to object, too many prior bad act claims, too many references to improperly admitted evidence in the closing argument, too many missing jury instructions, too many amended complaints, too many errors that all impact credibility, that what happens is the prejudice combines to create essentially this dark tapestry that overwhelms the trial jury and blocks them from considering what they're really supposed to consider. That's what happened here. As Justice Henry said in the Marquise Mitchell dissent, as unpalatable as it is to redo a trial, there comes a point where we cannot deny a new trial without damaging the integrity to the system. Jeffrey Knight did not do what the alleged victim said at trial, but you don't have to find him innocent. You just have to find that the verdicts might have been different. So I'd ask you to reverse, and if there are no further questions, my time is up.
Thank you. We'll hear from the Commonwealth.
Good morning, and may it please the court. Michael McGee from the Norfolk District Attorney's Office. My pronouns are he and him. I'd like to jump right into the prior bad acts or the other bad acts that occurred and were testified to on, I believe, day 2 of the trial. Much of the argument is about ineffective assistance of counsel, but a fair reading of that transcript will show that although in his affidavit, defense counsel suggests that there wasn't a strategic purpose to it, absolutely clear from that in his cross-examination that he was trying to establish that on no other occasion did his client touch anybody sexually, that he was nice to the young people, that they enjoyed talking to him about sports, and that this was normal behavior. He tried to utilize the fact that the classroom was busy and that it was dangerous, and that there was this red zone around the equipment requiring that an adult help with the students. There was absolutely a strategic purpose there, and what was clear throughout.
Counsel, if you go to the appellate's brief at page 24 to 25, for example, and also 26, there's a whole list of things that came in that defendant says should not have come in. In looking at this, should all of this have come in? Because there are a lot of things about him being a bad guy, him looking at another female student's butt in class, him knocking a pencil off the table and having a female student pick it up. Was all that admissible?
What the trial judge stated in his denial of the defendant's motion for new trial was that many of those, much of that testimony would have been, if it was objected to, may have not been admitted, and I don't contest that. However, what I would suggest is that much of that testimony was in relationship to two things. One, that you have a young victim here who's being accused of essentially like a retaliatory accusation of her teacher because of something that happened in a lunchroom a couple of years before, and someone that there's also an accusation, why did she delay in reporting this if it was a sexual act, and much of this testimony shows that atmosphere. And it also shows that this isn't just that this is an actual pattern of behavior, and that was also discussed by the trial judge, more so with MC, but that this was a pattern of behavior, that this defendant had going on in his classroom, that he acted like this towards women. I don't want to use the word prey, but essentially created an atmosphere that was uncomfortable and dangerous to people, young people in his classroom, to speak up, that they were afraid of him. He was a big guy with a barrel chest. He was 6'3", 6'4", something like that, among 13 and 14-year-old kids, and acting in a way such that they wouldn't report this to a supervisor. And that explained that and gave a full picture to the jury, and also went against the argument that this could have been an accident, that this was purposeful behavior on his part, and he took advantage of his situation of being essentially a shop teacher here and having this equipment, and suggesting that he had to reach over and had to rub his body up against or come close to an individual. And defense counsel simply tried to suggest through cross-examination that, yes, he got close and he did it properly, but you never saw him actually touch, or you never saw him come in contact with him on other dates. And that's essentially how the direct and cross-examinations of those young individuals played out. So those, and much of those questions Your Honor raises happened towards the end of a direct testimony, or was brought up through cross-examination. I would suggest the bulk of the testimony had to do with absolutely appropriate pattern behavior or rebuttal to that accident defense claim.
You have to define the pattern of behavior pretty broadly, though, to take that argument as correct, right? I mean, isn't there a narrower circle that you could draw around the prior bad act testimony that would include, for example, the testimony of the defendant's behavior toward the young women in his class, but leave out the testimony about the aggressiveness or threats of violence or physical touching of the young men?
I think those were two separate issues, and I know Judge Coven did an excellent job with the motion in limine about the prior bad acts, and I know that's in the record here, and how we limited it to the classroom. But the anger part, I would suggest, goes to this idea that, to answer a question in the juror's mind, why would this young person not report this? Why would she not tell her parents right away? Why would she be inconsistent in some of her stories or not tell the full story right away? It's because this overarching atmosphere of threatening behavior by a larger individual that's got a position of power in a classroom. And that's why that is relevant and probative of the acts.
Is it correct that the judge gave a contemporaneous limiting instruction on prior bad acts for MC's testimony, but not for any of the other witnesses?
That is correct, Judge, but contemporaneously, yes. Prior to MC testifying, Judge Coven gave a full prior bad acts instruction on that. Also gave an instruction at the close of evidence, I believe, as well.
Was the instruction at the close of evidence, did it expressly apply to everybody?
There was, my memory, and I'd have to take a look, is that it was a general instruction. It wasn't specific to MC or the like. But I think to your point, it was prior to MC testifying, there was a clear heads up to the jury that this is what you're going to hear about. You're hearing about a prior bad act. You're not supposed to consider this as propensity evidence. What you're supposed to consider this as a pattern of behavior or to rebut the accident defense.
So do you agree it was erroneous that the defendant was asked questions to comment on the credibility of other witnesses?
Yes, yes, Your Honor. It's a clear rule that prosecutors are not to ask a witness to testify about the credibility of another witness or any witness.
And my understanding is you're arguing that just wasn't a substantial risk of a miscarriage of justice, right?
That's correct.
If we conclude that the standard is prejudicial error, does the Commonwealth still prevail?
If it was prejudicial ever?
Yeah.
What I would suggest, and a good case on this, I know it's cited in my colleague's brief, but Sanchez here, is that this is a these are 3 isolated questions throughout a lengthy emotional trial, and even through the defendant's direct testimony. He was essentially testifying about things that people had testified to before. It's improper. It was improper to say, what are they lying, or something to that effect. But in the grand scheme of things, it didn't permeate the cross-examination. There was compelling, if not overwhelming evidence from a young victim who testified in great detail about what happened to her. There was corroborating testimony from one of her classmates that was BD that was in the classroom, and also from the first complaint, although vague. There was significant evidence here to suggest that but for that error, that this did not create, this did not change the outcome of the trial.
So you argue that we should defer to the trial judge's determination of whether something constituted a substantial risk of a miscarriage of justice. What's the authority for that?
I'm sorry, I missed that question.
You were saying that here the trial judge in the motion for new trial concluded that this was, and the prior bad acts issue, was not a substantial risk of a miscarriage of justice, and you're saying we should just defer to that conclusion, and I was asking what your case authority is for that.
For a standard of review?
Well, for us deferring to the trial judge's determination.
As cited in to that specific question, motion judge is also the trial judge, and should be given great deference here. I also would point to, as far as the prior bad acts, and a similar case, I know the Robertson case is an excellent case on that point. That was a case involving the victim was the same person in both the case that was at bar and also the case that was the prior bad act. Here, MC, the judge carefully limited this to what happened into the classroom and what MC went through, and how it was almost identical here as far as she was using the power equipment, and he leaned over and pressed his penis up against her. And I would suggest that throughout this case, the judge did use a lot of care in trying to, in allowing the parties to argue their points on the prior bad acts, but also to explain why he wasn't letting in the situation in the closet, and also any reference to the Superior Court matter, and carefully explained why, and talked about how, and citing cases within that and allowance of that motion to admit prior bad acts, that this was a pattern, and that the jury was entitled to hear about it.
Why was the mother's testimony about the investigation admissible?
Reread that again last night, and what I would suggest to the court is that testimony was carefully tailored to discuss the what steps the mother took to report this to the school and seek action. The substantive discussion about what happened, again, to my reading of it, and I may be wrong, came out through cross-examination. And this, again, goes to my initial point, is that throughout this trial, there was a strategic plan here by the defense to show that there was inconsistencies in the victim's testimony to her family, to the school, to her friends, and that in a lot of cases there wasn't this sexual contact. And he kept trying to establish that point. It was almost identical for each witness. And when it came to the mother and asked that similar question, she said, no, actually, what she told me was that he pressed his penis up against her butt. I don't know if that was an expected response, but that was the response to defense counsel, not to the prosecutor's questions. If there are no further questions, I'd rest on my
I
colleagues.
had a question.
Go
Sorry.
ahead.
A question about the record. The defendant maintains that the complaint was submitted twice to two different magistrates. What is in the record about that?
Complaint was sent to two different magistrates.
So if it helps, and it probably
Yeah,
won't,
I know there was
because I
some-
don't remember it that well, I think that the Commonwealth brief says there's no evidence of that. So I'm just sort of trying to figure out what the situation is.
I would point to footnote 2 in the Commonwealth's brief. On November 27th, 2018, there was a complaint issued charging the 5 counts of indecent assault battery. I don't want to get into I didn't want to get into the rest of that, but I don't have any, I don't mean to interrupt you. Is there another, beyond that, I don't know that there's another second complaint that was, there was amended.
Yes, it was amended.
Twice.
All right, I'll go back and read it. I thought there was an allegation that the complaint had been sort of judge-shopped and some requests for discovery around that.
I would only point to footnote 2 of the Commonwealth's brief. There's a brief history of its presentation to the grand jury as well.
Well, I also came away with the impression that the defendant was arguing that after the grand jury no bill, that the Commonwealth had gone to a magistrate who had denied the complaint and then went to a different magistrate who granted the complaint. So I take it your representation is that the Commonwealth applied to one magistrate and one magistrate only for a complaint.
That's my understanding, and it was the two issues was that it went before the grand jury twice, not that it went before a magistrate twice. That's my understanding of it, but if I'm wrong, I'll certainly correct my statement before the court today.
If ED was known to have lied about other students creating a sex tape, would that evidence have been relevant here?
I think it was well within the judge's discretion to not stray too far away from the issues that were at hand and was careful to stick with what happened in the classroom. And that there wasn't, and I believe the finding was that there wasn't a proper foundation for the veracity of that. And I can't, other than the chance that she had a propensity for lying, there's no other probative value of something like that. And that's not appropriate for court.
My last question I will then ask my panel is, at least it seemed like, according to the defendant, when he worked on projects with the class, he said he wore an apron and a tape measure. Given that evidence, why would he have been prevented from wearing an apron during his demonstration of the positions?
From my read of the record, it appeared that the judge allowed him to describe and show evidence and hold it up to himself, and that the judge was well within his discretion in controlling his courtroom to not allow to go any further than that and to simply describe what happened and to show how the apron was worn, and it speaks for itself and didn't cause any prejudice to the defendant.
Thank you very much. The case is submitted.
Thank you very much.
We're now going to call the second and third cases this morning, 2023 P0474 Commonwealth versus Eric Lawton Jr. and 2023 P0702 Commonwealth versus Troy L. Mitchell. And as I said earlier, we'll hear from each defense counsel, preferably without repetition. We'll hear from Mr. Lawton's counsel first, and then we'll hear from the Commonwealth.
May it please the court, my name is Attorney James Smyth. I represent Eric Lawton in this appeal. I'm going to try to focus on some things I argued in my brief that Attorney Ganguly did not raise, just so that, as you said, there's not much repetition here. The first issue in my brief was that the judge denied my client's constitutional right to assistance of counsel when she found him guilty without any oral argument. The the judge made a written decision on the required finding motion, and then when court convened on the next date, she told the lawyers, that's my decision, you read my decision on that, so you ready for sentencing? The lawyers seem a little bit confused about what she's doing, and then she says, well, that's my decision, and defense rests, so I'm finding him guilty. Neither counsel really said anything or objected, but I would argue that's not really necessary here because this is structural error. In two cases that I cited in my brief, the Miranda and the Martelli cases, there was no objection, and the cases were reversed.
Those were jury trials, right?
I believe that they were.
So why doesn't that make a difference here?
Well, I will admit that it would help my argument if the judge had said something along the lines of, as in those cases, I don't want to hear anything or don't bother saying anything, but I think here it's really the same thing because I'm sure the judge didn't forget that there's supposed to be an oral argument before she finds guilt on a bench trial.
Well, what if she did? Would it matter?
Pardon me?
Would it matter if she had sort of forgot? It was a weird procedural situation, right? So the trial hums along, it comes to an end. There's a motion for a, required finding. The judge is kind of crabby that the motion is oral and says,
Right.
no, this isn't how it's going to go. You
Right.
can all have some time to write. They talk about it. They pick a new date. They write. She rules. They come back. I don't think we'll ever know whether the judge just sort of forgot that there were no closings or decided I've had enough with these people. I don't need a closing. But legally, would it matter which of those it was?
Well, I think since it's a different legal standard, I think it's important for the defendant to be able to argue. Now it's a beyond a reasonable doubt standard.
Oh, no, I hear you on that. I'm asking in terms of our analysis, I would think that you would say, listen, it doesn't matter whether the judge on purpose denied this oral argument or just spaced out and there was no oral argument. What we need to look at is my client's rights.
Right. So I don't think it matters whether she forgot or intentionally did it. I can't believe that she actually forgot. I'm sure she handled a number of bench trials before. So I would argue it's basically the same thing. The fact that she didn't say anything like, don't bother arguing, I think this is basically the same thing. She denied the right to make the oral argument.
Do you have any case where we or the Supreme Judicial Court concluded it was structural error when there was a bench trial?
I don't recall. Whatever I cited in my brief is all that I had.
So the Commonwealth argues, well, this is a different circumstance from the cases you cited, other than the jury part of it, that basically where the defense counsel had written out why this wasn't even, why a required finding should have been granted, that in effect gave the judge the full picture of why this, wasn't beyond a reasonable doubt. It wasn't even meeting the minimum element here. So why is that wrong?
Well, as I said, it's a different legal standard before you find a defendant guilty. And I think that the defendant has a right to have their counsel argue that it's not proof beyond a reasonable doubt.
Okay. Could I back you up for a minute on the stipulation? I mean, obviously this was sloppy, and one would hope the Commonwealth is explaining to all of the young ADAs that they need to put a stipulation into evidence. But leaving that aside, it was entirely unclear to me how the judge knew about the stipulation, because it seemed like everybody agreed. Somehow this happened, but it's very hard to tell from the record.
Well, obviously my argument in my brief was that the stipulation is invalid because it doesn't comply with the rules of criminal procedure. It's not signed, as you said, it's sloppy. It's not signed by the defendant. It's not signed by the prosecutor. And it's never mentioned during the trial. And the Rule 23A states specifically, quote, shall be read to the jury before the close of evidence. Now, we didn't obviously have a jury here, but it's got to be read at some time during the trial by the DA. I would argue
It's the same thing. If the judge knew about the stipulation, then what's the concern here?
Well, because there was also no testimony by the alleged victim that identified the defendants in court or gave any description, so there was no identification in court whatsoever. I'm sure Attorney Ganguly is going to get into that, but so without the stipulation, which I argue is void, and then there is no identification of the defendants. She doesn't ask, it's kind of odd because as you say, I'm going to find defendants guilty. Was there a stipulation? But I would argue at that point, it's too late because she's already found him guilty. But ask about a stipulation after that I find the evidence insufficient on identification.
It's an interesting issue, counsel, because a stipulation to all the elements would require a colloquy. And essentially there was a stipulation, or there was a proffered stipulation to the assault and battery and identification. For that to be valid, would there need to be a colloquy?
I don't think there needs to be a colloquy, but I think it's, at some point, I know it wasn't introduced into evidence, which apparently is not a requirement according to the rule, but I think it's got to be presented, it's got to be read to the judge, since this was a bench trial.
Well, the trial went to, or the matter went to trial on the basis of the aggravating, the sentencing factor, the injury, correct?
Well, if you credit the stipulation.
If you were to credit the stipulation.
Right, which I'm not, correct?
Then if you accepted my word for it, then if a stipulation is to all the elements of the offense and the identification, there must be a colloquy. It's similar to a plea. But part of the reason I ask is you're not aware that there was any colloquy or any, that the stipulation was addressed.
There certainly wasn't any colloquy that I read, and it wasn't addressed. And the other issue here is, as far as the co-defendant is concerned, is does it even apply to the co-defendant because it's signed by counsel for Mr. Lawton, and it just has his caption and his docket number, so I don't know if it even applies to the co-defendant, but I can let her obviously address that. But.
Well, it's an interesting issue because the rule does require it be in writing, signed by the defendant. But we just seem to be missing something, or maybe we're not. I mean, the trial begins with, for instance, a commentary about the medical records not being introduced. So it leaves one to wonder, if right before that, there was discussion about there's a stipulation. And that's not before us, it's not part of the record, but it just seems, the first mention of it seems peculiar that it's after, essentially after the verdict.
Right, right.
But the defendants did obtain an advantage from the stipulation, right? Because that's why the assault and battery by means of a dangerous weapon was, I think, null-prost.
Well, there was no evidence of any dangerous weapons, so I don't.
Well, it was December, and there was testimony that the defendants kicked him. So it seems like one could infer, even in these times of climate change, that they had shod feet.
Yeah, I don't think there was anything in the record about that. I understand what you're saying, but I don't think they got a benefit by the stipulation. I can talk briefly about the second issue in my brief was about the denial of the most required finding on serious bodily injury, and I wanted to talk a little bit about the bill of particulars that was filed by the Assistant DA prior to the trial, which indicated their theory was substantial risk of death. And then a week after the trial, after the evidence was already in, they amend their bill of particulars to add in the loss or impairment of a bodily function, limb, or organ, and I would argue that they should be held to the bill of particulars that they filed prior to the trial. They can't change it after they hear the evidence, and it makes a huge difference, I think, here, because there certainly wasn't evidence of substantial risk of death. I don't think that's...
Why is it not enough that the first bill of particulars alleges a brain injury? I mean, when it alleged the brain injury, did it say, but we're not claiming injury to an organ or part of the body?
Isn't the brain an organ?
Yeah. I mean, they allege injury to the brain via the hematoma, and also, I think at some point, concussion, but I don't remember if that was in the bill of particulars, but the hematoma was definitely in there. So why does that, even if they indicate that might have had a substantial risk of death, why does that not just take out the other theory for criminal
I
responsibility.
don't remember the exact wording on the first bill of particulars. I know it was like one short paragraph that, other than looked like to be a form, but I would say it's substantial. It just basically alleged substantial risk of death, which I think is a big difference if you're preparing a defense based on substantial risk of death rather than loss or impairment of a bodily function, limb, or organ. I think the Commonwealth should be held to the original bill of particulars.
And what's your best case for the proposition that when the Commonwealth elects a theory of proof in the bill of particulars, the Commonwealth must be held to that theory?
Well, I don't know that I have a case that, in my brief, specifically on that. I know the case law basically says as long as the defendant can prepare a defense, I think that's basically what the case law says. But here I would argue that they couldn't prepare a proper defense if they're basing it on substantial risk of death.
So just to answer your earlier question to the world about what it said, I think the statement you're thinking of is at page 9 of the record appendix, which is, during the assault and battery, Mr. Gay suffered a traumatic subdural hematoma, which, according to emergency room physicians, placed Mr. Gay, quote, at high risk of a serious or life-threatening situation, close quotes.
Well, I would still argue the Commonwealth should be held to their theory that it's a substantial risk of death, and that the defense would be preparing a defense based on that.
And granting that, let's say we went with you on that point, you're saying that the evidence only presented by the victim of the hematoma on the brain and all the treatment, you don't think that qualifies as risk of death?
I don't think so based on the testimony, no. I mean, I can go into what he testified to, but I'm sure you know what it is. I would argue that's not a substantial risk of death based on his testimony. And obviously, this would just, if you agree with me on this, I believe it would just reduce it from the substantial bodily injury, serious bodily injury, to just a straight assault and battery, but that's still important for my client. It's the difference between a felony and a misdemeanor.
On that note, the judge was very straightforward at sentencing in repeating, I think at least a couple of times, that the sentence that she was imposing was no different from the sentence she would have imposed absent her finding of serious bodily injury. In light of that, can you articulate what prejudice your client suffered if this was, if something went wrong in this process?
Well, again, it's the difference between a felony and a misdemeanor, regardless of what the sentence is. It's important to my client whether he's convicted of a felony or a misdemeanor. So
it's not just the sentencing, it's the collateral effects of having a felony conviction.
Right.
Where the victim testified that they suffered a concussion and a hematoma, so in other words, a brain injury, and then reported significant period of delayed thinking and speech, if we think that the Commonwealth did articulate a theory as the loss or impairment of a bodily function, limb, or organ, why would that not be sufficient to meet that standard?
Which standard now are you?
If it was loss of or impairment of a bodily function, limb, or organ, why is a concussion and hematoma with delayed thinking and delayed speech not sufficient to meet the standard of substantial bodily injury?
I'm not really going to argue that right now. I mentioned it in my brief. I think Attorney Ganguly will probably reference that because she said more in her brief about that. But
all right.
If we agreed with you, or under your theory of the closing argument, the absence of a closing argument, are we to evaluate the strength of the evidence in determining the effect of that error?
Well, I suppose you would have to look at what the evidence was. Well, I think not really, because I think if you agreed that there was no closing and the judge precluded closing, that's a structural error, it's a constitutional violation, so I don't think you really have to look at the evidence there.
Thank you.
Thank you. We'll
Thank
hear
you.
from counsel for Mr. Mitchell, Attorney Ganguly.
Good morning, Tara Ganguly for Troy Mitchell. My argument regarding the identification issue is slightly different, although I do also agree that the stipulation, there was a stipulation for Mr. Mitchell, it's in the Commonwealth's Record Appendix at page 3. Also was only signed by trial counsel for Mr. Mitchell, was not signed by the prosecutor, was not signed by the defendant. That was, as my brother said, not properly admitted, not properly done according to the rules of criminal procedure. But if this court is going to overlook that sloppiness and say, well, as Justice Smyth was saying, it's weird because the docket in at least my case says that there was a plea. The docket indicates a plea. There was no actual plea colloquy. It seems that the clerk may have assumed that the stipulation somehow was a plea, but there was never any colloquy. So I think that's problematic. But for sake of argument, assuming that the stipulation stands, the Commonwealth never had its sole witness, as in every case we've all ever seen, look over and say, that is the person who assaulted me, sitting at counsel's table. It never happened. There were 4 individuals, 4 perpetrators the night of this incident. There were 2 people sitting at counsel's table. There was an unknown 3rd co-defendant somewhere out there floating in the wind that was mentioned briefly in the record, who for some reason was not tried with these other 2. We don't know who inflicted serious bodily injury on Mr. Gay. They weren't tried as a joint venture situation. I know it was a bench trial, but judges are still supposed to identify if they are, there was never any mention of joint venture anything. And if the judge was sort of thinking that way, she should have said, okay, I'm instructing myself as to XYZ. That didn't happen.
Right, but here, where there's the stipulation without a colloquy that they committed the crime of assault and battery on this person, why, the only issue at trial was whether or not he suffered a serious bodily injury. So why would he identify the defendants as the people who hit and punched and kicked him?
Because what if it was one of the other 2 people who actually what if, for example, Mr. Mitchell stipulated to assault and battery? Possibly he hit him once. I don't know. No one was there. And it was the other 3 or the other 2 or 1 who kept hitting him, kept punching him, kicking him, and that person or persons actually inflicted a serious bodily injury. We just don't know who inflicted a serious bodily injury. There were a lot of assumptions in this very short bench trial. It was sloppy. I know the district courts have to keep things moving, but there were things that were not done that procedurally sort of turned everything into the mess that we're dealing with.
But is that argument really sufficiency of the evidence, or is that pertain to identification?
I think it pertains to identification because I think a cleaner way for the Commonwealth to have done this, which would negate my entire argument, would have been for the prosecutor to say, Mr. Gay, can you identify in the courtroom the person or persons who punched you in the head, punched you in the face, causing the hematoma that you're talking about? Yes, the person sitting right there with the blah, blah, blah tie. That's how it's normally done. It was just not done here. And sure, we can assume as to who's sitting at counsel's table, but it's not proof beyond a reasonable doubt.
In light of thank you for pointing us to the stipulation from your client in the record of that case. as I read it, there is a reading of it that seems to me to be not unfair, that does away with the need for the kind of classic identification that you are talking about. So the stipulation, and now I'm at page 3 of the supplemental appendix in Mr. Mitchell's case, the first, number 1 is that Eric Lawton and Troy Mitchell did commit an assault and battery on Philip Gay. Count 2 is a concession, presumably, in light of or in exchange for the stipulation, but
Right,
put that
only
aside.
as to Mr. Lawton.
Only as to
Mitchell
Mr.
was
Lawton.
not charged with ABDW.
And then 3 is that the only issue at trial is whether the assault and battery caused serious bodily injury pursuant to the statute to Philip Gay.
I see exactly what you're saying, the only issue at trial. But if we're going to take out identification of the defendant from something that needs to be proven at trial, I just don't think we can do that. I mean, if you want to be very specific and narrow about language here, I think you have to be equally as specific about how it was filed or not properly, admitted or pled to or whatever. I mean, the court can, of course, in its own discretion, pick and choose the language in any part of the record that it wants to grab onto. But the only issue at trial, I think a reasonable reading of that is what it says, is the serious bodily injury. Not that, Joe Schmo off the street can come and sit at council table and the person who actually did it doesn't even have to be there, which is the possibility that we have.
If there were only one defendant in this case, could you make the same argument?
Yes, I don't see why you couldn't.
Okay. So I just wanted to tease out, your argument doesn't rely on the question you raised earlier of, who was it who really, this is legal, technical language, beat the crap out of him versus who was there and may have thrown one punch.
Right, I think having two people sitting there and having no identification makes it even worse than having just one. I think the argument stands with one person there, but I think it's worse with two people there.
So you're saying it's possible that one of them, if the injury was to the brain, you're saying it's possible one of the defendants only kicked him in the stomach and therefore can't be liable for serious bodily
Correct.
injury? Okay.
The only thing I'd like to point out about the evidence for serious bodily injury, I'm not going to repeat what my brother said, but I would argue that the testimony, you did testify that you have no long-term injuries. Is that correct? Mr. Gay answers, sure. And that's on page 29 of the bench trial.
But serious bodily injury doesn't have to be long-term, right? I mean, it's the impairment of a major life function, and I think I can't cite them off the top of my head, but there are cases where it's, a few weeks or a couple months or something, and that's adequate.
Right, but I think the fact that there were no medical records and we're just going off the testimony of what he said, and his testimony was not very specific. Yes, he says he has some speech issue, but it doesn't significantly impede him to the extent that, he was promoted at work, he works 60 hours a week. No fractures, no surgery, no hospital stay. Just one other point.
Well, let me ask about the hospital stay.
There was an overnight, I apologize.
In your brief reference, he was only there 12 hours to stay for occupational therapist, but his testimony was quite different, that he was on kind of a 24-hour watch because of the brain bleed. How do you reconcile that?
I think there was, during cross-examination, I remember he may have changed his testimony he may have said I was there for 24 hours during direct testimony. I believe he changed his testimony on cross-examination. I apologize, I don't know the exact site. But even if he was there, longer, it was for observation only. And it's worth noting, again, that as my brother said, and this is the last thing that I will repeat, but it is important, is that the difference between a felony and a misdemeanor is not nothing for collateral consequences. And just because the judge would have sentenced, she says, the same way, is irrelevant to whether there was sufficient evidence of what they were actually convicted of in this case. If there are no further questions, I'll rest.
Thank you.
Thank you.
So for the Commonwealth, we'll put 20 minutes on the clock, and if that seems insufficient, we can cross that bridge at that time.
Thank you, Your Honor. May it please the Court, Cynthia Von Flatern, Assistant District Attorney, Northwestern District for the Commonwealth. The Commonwealth submits that, I'll address the arguments in the way they were presented, if that's agreeable to the Court. The interesting issue about the closing argument that there was not a substantial risk of a miscarriage of justice for the fact that the attorneys did not argue in closing. As you know, they had the trial, and then when it came to the motion for required finding, the judge requested that they put their argument in writing because it was a complicated issue, and that was what the trial boiled down to, whether there was substantial bodily injury or not. So the parties had a few weeks to make those arguments. I would submit that...
That's after she denied their right to make an oral argument.
Yes, on the issue of the required finding, she said, I would like this in writing because it was complicated. But of course, the trial hadn't ended. It was only the motion for required finding, and then there was a new date, and these briefs were submitted. At that time, one of the attorneys asked, are we arguing required finding or guilt? And she said, she said, is this a decision on required finding or guilt? And then she said, well, I've had your arguments, you're not giving any additional evidence, so I'm going to find guilt. But they had an opportunity to ask for closing argument. She did not foreclose closing argument like the cases that are cited in the briefs. And
I don't know if I agree with you there. She didn't say anything as extreme or explicit as the case is cited, but she gave them no chance. She basically said, this is my finding. Were they supposed to, how were they to know she was going to say, I've denied your motion and this is my finding?
Your Honor, I think that she didn't make, it was clear that she had carefully considered the evidence. She had already made a written determination on the motion for required finding, and then the parties went back together. That would have been the time for the parties to ask for a closing argument. And she had done a lot of...
You never ask for a closing argument in a trial. You're entitled to one. You never request one.
Well, I think there can be waiver of the closing argument, Your Honor. They are entitled to, and that's true whether it's a bench trial or a jury trial. But I think in this case, they had argued so well in their written briefs that they had waived the oral closing argument.
So he says, well, it's a different standard. Why does that, and obviously your response would be, well, that doesn't matter here. So why does it not matter here?
Well, it is a different standard, but we didn't have any evidence from the defendants. The judge knows that some evidence is considered in the light most favorable to the Commonwealth if it's for the motion for required finding, and then it's the light most favorable to the defendant on the issue of whether there's guilt or innocence. But the judge will correctly instruct herself and can make that determination. So particularly where there is no conflicting evidence from the parties, from the defendant, there would be no substantial risk of a miscarriage of justice in the way it went in this case.
So could you back up to the stipulation, because in the record, I just really don't understand, how do we know the judge knew about the stipulation?
Well, she she references it in her decision on the motion for required finding. It is in the record on Mr. Mitchell's record appendix. It's the clerk has entered the stipulation into evidence. All the parties agree and write their motions for required finding that there is a stipulation, that the parties have entered into a stipulation on the assault and battery, and there's also a stipulation that Mr. Lawton has not committed assault and battery with a dangerous weapon, that case is going to be dismissed.
And do you know, I thought it was Mitchell that didn't commit. Yeah, it's only Lawton was charged with ABDW. Do you know why
Right.
that was?
Why he was, I'm not sure why he was charged, and
Really, I'm more interested in why the other guy wasn't.
I don't understand. I think that's almost, it doesn't, they should have been both charged, so it's not consistent, but and that may be one reason why it was dismissed. I think it's also dismissed as, you know, there's an agreement amongst the parties, and it is valuable to have that charge dismissed for Mr. Lawton.
Here, the defendants didn't just agree to an element of a crime. They actually agreed to an entire crime, right? And there was no colloquy.
That's what it amounts to, and I think that's the trickiest part of this case is that they did agree to identification, or they did agree to what amounted to the assault and battery, and that was really the gist of the case. Everybody agreed that the issue for them was the substantial bodily injury, or the serious bodily injury.
Actually, maybe I'm putting the cart before the horse. We can't really, I don't know if it's just that the defendant didn't provide us with the right record. We can't tell that there was no colloquy, I think, from the record provided. Was there a colloquy on this?
Your Honor, I believe that there was no colloquy, and just because the parties jump into it, and they don't reference a colloquy. So that's my understanding. It would be.
What about the fact that the stipulation is not signed by the defendant or the prosecutor? But let's focus on the defendant here for a moment. What do we do with that?
Well, with respect to the prosecutor, I don't think that there's any harm to the defendant, to the defendants themselves, by the fact that the prosecutor did not sign it. It's certainly understood by the prosecutor that there should be a stipulation. I think the Commonwealth now is more concerned that the defendants themselves have not signed the stipulation. But this case goes on. The attorneys do a good job on the motion for required finding. There's no concern on anyone's part on the bodily, or on the assault and battery. And I do think that brings up the argument that my sister has in the Mitchell case, that there is this, well, and they both argue the issue about identification. The Commonwealth has moved to expand the record to show there was a whole hearing on identification, and the testimony from the officers was that they get there quite soon after this is called in, and they see people running near the victim, and they cut them off with the cruisers, and those two people that they find that they cut off are the two people that the victim identifies. And the issue was whether that was a suggestive identification, but there was even identification and then another identification, which was sort of like a show-up identification.
Not to interrupt you, that has no bearing on what happened at trial, though.
Well, it goes to the issue about identification and whether that really was an issue. So it goes to why these parties would have stipulated to the assault and battery, and I think that was my sister's argument, that there's an issue of identification. And our argument is when you get into the stipulation, then you have identification. So I think the serious issue is whether the stipulation binds the parties here.
And you didn't, I'm not sure you got a chance to answer Justice Henry's question. What about the defendant not signing it? Is that not significant? I mean, the statute says shall, correct?
I think that the Mass Guide to Evidence says shall, and that talks about in a jury trial. I think that would be a best practice for sure, so that the jury is not confused. But when you have the bench trial, the judge is not confused. And I would submit in this particular case that the defendants were not confused, that that's how this would have been laid out. There's no argument that there was ineffective assistance of counsel here, and so I think that in this case that the defendants' rights have been safeguarded sufficiently. When the issue is, it really boils down to whether this is a felony or whether they have committed misdemeanor assault and battery.
So what about her argument that maybe one of them kicked him in the victim in the head and the other one kicked him in the stomach, and so he needed to have said, they kicked me in the head?
On the facts that were testified to by the victim, it's clear that these two individuals that he was sustaining multiple punches, and I don't think you could, in the days where you had to say who was the stand-byer and who committed which punch, I don't think you could even do that in this case. It was very clear that they were sharing the punching and the kicking, or at least the punching. And then, of course, we had the dismissal of the dangerous weapon assault and battery. If there are no further questions, the Commonwealth will rest.
Just a few more. On the stipulation, I thought you referenced it was introduced. There was an indication it was introduced in the record. I've looked at the docket report. I can't find it. Can you tell me where there was evidence it was introduced?
Your Honor, in the record appendix, in Mr. Mitchell's case, in the record appendix, that the stipulation is on the record.
Well, I see the actual stipulation. I just don't see where it was introduced on the record.
It's in the record appendix, Sharon. I think it's in the Commonwealth's.
I think you're talking past each other. I think Judge Smyth is asking about introduced in evidence rather than noted on the record.
We will not find it in the transcript, Your Honor.
Okay. And as for the issue about the nature of the injury and whether the switching to, again, whether the bill of particulars should be viewed narrowly as a defendant's claim or more broadly as a judge claims?
The Commonwealth submits that that we should look at this broadly as the judge looked at it, that there was sufficient evidence on that there was substantial risk of death and also loss of or impairment of a bodily function. There was an amended bill of particulars that added this loss of memory, loss of speech, and as the judge found, and as Pillay and Crawford would be the two cases cited in the Commonwealth's brief, the defendants were on notice about what the injuries were in this case. So the amendment of the bill of particulars in this case was fair. The evidence was particularly strong. I would submit that there was a loss of bodily function because the victim testified not only, he first testified that of a vicious attack, a lot of bleeding, punches to the face and head, and then that he has had impairment of his speech. He has speech delays and memory. And as the judge pointed out, because there was a delay with the trial, this was COVID times and everything, I don't know why, I think that's probably why it delayed, but there's not a mention of that. But there was a 2-hour, the victim had 2 years between the date of the incident and the time testifying, and he was testifying that he still had this impairment.
But that would go to impairment, not substantial risk of death.
That went to impairment. A substantial risk of death would be the testimony that, his testimony that he had a concussion and a hematoma. And of course, we do not have the medical records in evidence, but we do have his testimony on that. And it's not like he's pulling that out of thin air, I would submit. He testified to that attack, and he testified to the impairment, as well as the hematoma and concussion.
Thank you very much.
Thank you.
The case is submitted.
Thank you all for traveling. Really appreciate it. Safe travels.
We'll go ahead and hear the next case, the fourth case for today, and then we'll take a morning break. This is case 2023-P-0249, John Doe number 526553 versus the Sex Offender Registry Board. We'll hear first for counsel for Mr. Doe.
Thank you. Elizabeth Caddick for John Doe. May it please the court. This case involves a number of legal errors and prejudice arising from them. The most significant mitigating fact in this case concerns why this otherwise well-behaved boy who has no other criminal history would have committed such a sex offense. And what we have is 2 months before the sex offenses started, he began testosterone injections for delayed puberty. And as the expert testified, he consulted all the medical records. He consulted with a medical doctor who also looked at the medical records and stated that it was the rapid increase in testosterone in an immature 15-year-old that lowered his inhibitions, increased his anger, increased his sex drive, and he was incapable of controlling this and using any maturity that someone older would have been able to have used. And it wasn't the testosterone, it was the unnatural increase, because whereas in adolescence, the increase in testosterone takes place over years, in this case, according to the medical doctor, it was immediate. And he stated that it was more likely than not that the rapid increase in testosterone contributed to the sex offense. Now, what also contributed to the sex offense had to do with the boy's immaturity. He was more immature than the average 15-year-old because he had been bullied because of his short stature and his delayed puberty. And so he withdrew from social contact, which led to his greater immaturity, but also his inability to relate with other people properly. Now, this evidence of the rapid increase in testosterone was initially ignored by the same hearing examiner. That decision was vacated by the Superior Court because, as he stated, she totally ignored the testosterone. So on remand, she ignored it by simply stating the expert or the Doe never submitted medical records. Well, what Doe submitted was all the information from the medical records, both quoted by the expert and through the expert testimony in his consultation with the medical doctor. That was a...
I want to pause you on that because you say she relied on the not submitting the medical records, but there's two pieces to that. And I could see you have a stronger argument if it was just he didn't submit the medical records, but she specifically also focuses on medical records that might have contained some sort of contemporaneous corroboration that Doe was reporting effects. And so those two seem very different. Why was the part about him and what he was reporting, why was that improper?
Well, because she's still referring to the medical records, and what we have is the expert consulting with him using what information a medical expert uses in order to make a decision about a diagnosis and for risk to reoffend. And if, according to the rules of administrative hearings, reliable hearsay is admissible, and certainly what was admitted by Doe was reliable hearsay. If, according to the rules of evidence, even at trial, which of course administrative agencies don't have to abide by, but even if you look at the rules of evidence at trial, medical records do not have to be admitted if the expert testifies that he relied on the medical records and they would be otherwise admissible. Now, these medical records, physicians make life and death decisions all the time based on medical records. And so certainly it's appropriate for a medical doctor consulting with a psychologist and a psychologist testifying as to what's in there. If according to the rules of evidence, if the other party wants those records admitted, they could ask that they be admitted. That never happened here. The hearing examiner never complained during the first hearing that those medical records were admitted, never complained at the second hearing, during the hearing, that those medical records weren't admitted. And all of a sudden, to find a new reason to ignore this very mitigating evidence, comes up with this legally incorrect reason. And the fact that the
So do you think the board should be foreclosed when the hearing examiner just ignores an expert report, then when it's sent back to say, consider the expert report, that they shouldn't be able to find a reason why the expert report's not persuasive?
Well, according to the law, the only time a hearing examiner can ignore an expert report, an expert's testimony, an expert's evidence, is if they give an objectively reasonable and explicit reason for rejecting it. And she did not. She certainly didn't with the testosterone testimony. All she said was he didn't admit records that confirmed what I think no medical doctor needs to know is what the effects of testosterone are in a juvenile and what rapid increase of testosterone would be on a juvenile, that it would increase his sex drive, that it would increase his anger and his impulse control problems.
So just to pause you, my understanding of the record is that Dr. Saleh's report did not submit a report. It's just that the other fellow relied on the conversation with him.
Yes.
Okay.
Yes. And I would argue that that's totally legitimate and accepted in even in courts of law, certainly administrative agencies. And what the hearing examiner also did is used the improper wording from Factor 12 that had been declared unconstitutional. Initially mentioned it in the first report. It was vacated because she relied on Factor 12, which not only had those two sentences that were declared unconstitutional, but also Factor 12 didn't apply to juveniles except if they were found and they continued to offend, and that never happened here. So on remand, what she did was include it as Factor 37, the sort of catch-all, any other useful information, and then used it for dangerousness. Now, there are a number of problems with that. One is there's still no empirical evidence that repeated sexual offending before apprehension increases dangerousness. Just that there's no empirical evidence that it increases risk to reoffend, there's no empirical evidence that it increases dangerousness. Also, the declaratory judgment that declared those two sentences of Factor 12 unconstitutional specifically mentioned 3 separate times that there's no empirical evidence that repeated sexual offenses without apprehension increases risk to offend or dangerousness. So specifically, that opinion mentioned dangerousness. And the prejudice from all this is because...
When you say the opinion referenced dangerousness, are you talking about this particular opinion in this case or the earlier Wilkins?
The declaratory judgment.
Yeah, okay,
yes.
Okay, in this case, all right.
The declaratory judgment that declared it unconstitutional, that SORB didn't appeal, and that this court has stated is now law. That decision mentioned dangerousness 3 times along with risk to reoffend. And so the global holding of that decision is what actually the SJC has said multiple times in the SORB cases, is that in order for the offender to get their due process rights to a fair hearing, any risk enhancing factor that SORB uses or dangerousness enhancing factor that SORB uses has to be based on empirically validated research. And it was not here. There's nothing anywhere in the regulations that state that repeated behavior before apprehension increases dangerousness.
So I just want to make sure that I'm following this argument, and you please tell me where I go wrong.
Okay.
But what I understand you to be arguing is that due process constrains the hearing examiner to considering the offense here without reference to whether Doe abused this boy once or 50 times or 100 times before Doe was apprehended. Do I understand that correctly?
That's correct.
And that the legal basis for that contention is the statements in Doe 22188 by Justice Wilkins, which have not, which are now law, that when he was ruling on factor 2, which has to do with the likelihood of recidivism, also mentioned dangerousness.
Right. And the additional part of that argument is that not only did really the holding of that declaratory judgment, that there has to be an empirical basis for any finding by SORB for either risk to reoffend or dangerousness, but the SJC has stated that there has to be an empirical basis for SORB to find what they need to find, which is risk to reoffend, dangerousness, or the need for internet
So
dissemination.
as I think SORB counsel points out, the requirement for a trial judge to do their best to determine dangerousness is obviously not confined to this procedural situation, right? And I'd say trial judge, which, in this case, it's a hearing examiner, obviously. But 58A, sort of the most obvious corollary. In those cases, I'm not aware of any requirement of empirical evidence. Is the thing that makes this different that it's pursuant to the sex offender statutes and regs? In other words, that the judge, or in this case the examiner, can't sort of rely on the sort of things that a judge would rely on in making this determination?
Well, it's not that, I don't know of any case where the SJC compared what a hearing examiner can do compared to what a judge can do in a criminal case. But what the SJC has made clear is that in order for there to be a due process, the SORB has to have an empirically valid basis for finding what it has to find, which is risk to reoffend, dangerousness, and the need for internet dissemination. And so although intuitively it may sound like it doesn't make sense that if someone offends once or someone offends 100 times before they're apprehended, that the 100 times doesn't elevate their risk to reoffend, the research is clear it does not elevate their risk to reoffend. It's if they reoffend after they've been apprehended that elevates their risk to reoffend. Now, if it's 100 times versus 1, that would certainly affect punishment, correct? Because it's worse, and the effect on the victim was worse. But if you're looking at reoffense risk, and the current reoffense...
But I think we're not. I mean, I want to keep you focused on dangerousness because that's the thing you're complaining about here, right? Is that factor 37 was used as sort of a backdoor to get in this factor 2 stuff on the ground of dangerousness as kind of a fig leaf. And I guess, with respect to, it's a different, the regs make it different. Dangerousness is different from risk to reoffense. It's a separate inquiry.
Right.
And so I guess what I'm trying to figure out is why it's mandatory to map the risk to reoffend requirements onto dangerousness. And you say because the SJC says so.
Yes, because it's one of the 3 things it has to do. And the SORB factors do deal with dangerousness when you look at what they consider more dangerous. And so actual criminal history, not number of times offended before apprehension, but actual criminal history, that raises your risk to reoffend. Anything that the research shows. So it would be, other lawlessness, even if it's not a criminal history, which this a boy did not have. And when it gets, if we go to dangerousness, stay on dangerousness. The hearing examiner also made an error when she appeared to argue, because she said he had an interest in a young boy, and there's no evidence that he's a pedophile. There's no evidence that he has any mental health illness, but she was mentioning it as if he's going to, if he reoffends, he's going to reoffend against a young boy. And the research shows that juveniles offend against other juveniles because that's who's there, and that the reason juveniles offend is very different than when an adult offends. So an adult who offends against a 12-year-old boy is very different than when a juvenile who has, matured out of their offending behavior. And it's related also to how she didn't look at his current risk to reoffend. She just kept focusing on the now 9-year-old crime at the time of the hearing, the second hearing, the 7-year-old crime, and didn't look at the boy who was now matured.
Your time is out, so I think we understand that. I do have a couple of questions for you. On Dr. Saleh, the board argues that he was unable to make a concluding statement, or that Doe would not have offended absent the testosterone. So what do you say to that?
Oh, because it's the fact that he said that it was a contributing factor is enough for mitigation. It would actually be, I would say, he wouldn't be as candid if he were to say, oh, this was the only reason. Because we all know that sex offenses are related to a number of factors, and that's why there's 37 factors in SORB's regulations.
And then as to factor 13, are you arguing Doe was not under community supervision when he was in a DYS residential program?
No, that's not what I'm arguing, because they do say that being in DYS custody falls under the wording of that. It's just that he never had any disciplinary reports. He never sexually misbehaved. He got, student of the week multiple times, or resident of the week, and that he was immature when he first entered a youth facility. Well, it's not a risk elevating factor to be young when you go into a Department of Youth Services facility. He did not misbehave.
I think we understand.
Okay.
Okay, thank you. We'll hear from the board.
May it please the court. Roxanne Greenaway for the board. First, I wanted to address the factor 2, factor 37, and the dangerousness.
We're going to need you to speak up, though.
Okay. First, I wanted to address the factor 2 and factor 37, the dangerousness inquiry. And I would just point out, as we look at any hearing examiner's decision, there are 3 inquiries that are made and 3 determinations that are separate that has to be made. So where you have the risk determination, the dangerousness determination is completely separate from that. And here you have actually some support in case law, albeit it's a Rule 23 decision, DOE 360651, which points out that you can take into consideration the repetitive conduct, sexual misconduct and sexual offensing.
I'm not sure it was emphasized in that case as it has been emphasized here, that Judge Wilkins specifically found in DOE 22188 that there is no data or peer-reviewed literature to support the proposition that repeated sexual offenses are compulsive or even predictive of reoffense, but this is the important part, or dangerousness. So how can the board consider dangerousness under factor 37?
When you look at the 2 sentences actually that are stricken from the regulation, and this is in factor 2. So
yes,
when we're talking about Judge Wilkins' decision, we're specifically speaking about factor 2, not factor 37, which takes into account other useful information about a sex offense that may point to that. So when we look at factor 2, he's taking out the sentences that really pertain to risk, and that's the only part of that factor that is taken out. Now, factor 2 does not apply in this case. So in Factor 37, a hearing examiner can certainly take into account the repetitive sexual crimes that were committed against the boy over an 8-month period, 8 to 9 month period, and certainly can look at that and say that the harm that would befall a future victim, were they to go through that same type of victimization, does make Doe more dangerous.
So that has a lot of logical appeal, but my concern is that this repetitiveness was dealt with specifically in a factor, and then it gets stricken from Factor 2. And it seems like now the board is bringing it in under Factor 37 over a finding that says it doesn't tell you about dangerousness.
Well, when you look at each of the factors again, Factor 2 does not apply in this particular case, so you cannot.
Right, because he wasn't caught.
Right. So we cannot take that into consideration. So we have to look at factors that are not applicable, don't weigh for or against an individual, so we just have to not take that into consideration.
No, I know, but I'm talking about in structuring the factors, there could have been a factor that says repetitiveness is dangerousness, and there isn't.
Well, I can tell you, Your Honor, well, these are the older factors. They are under construction right now, but these are the factors that we do have. And so the factors that we do have, we have to operate with what we have. And in those factors, while you don't have one that specifically talks about the repetitive nature of sexual offending in conjunction with dangerousness at the current time, you do have Factor 37 that gives a hearing examiner that discretion to look at that type of behavior in determining someone's dangerousness.
Right, but that can only happen if there's empirical evidence to support it, right?
I do not agree with that necessarily. I do not think that there is any case law that says that every single factor has to be, that there's a must, that there must be empirical research to support them all. However, I would point out that the factors are properly promulgated, and they're all determining current risk. So we do have to take into account what one would say a catch-all category, that Factor 37, just like you have, for instance, if an offender were submitting articles that are not considered by the current regulations, that is the factor that a hearing examiner can take that into consideration. And not just articles, that's just an example, but any other information that they wanted a hearing examiner to consider in a case.
So in this case, the hearing officer was told on remand to resolve the discrepancy in the time frame. Was it 4 months or was it 9 months? Mm-hmm. And I can't, it's clear that on remand, the hearing officer just says 9 months over and over again, but doesn't actually confront that, and the evidence that cited all seems to say 4 months.
Well, if you look at the hearing examiner's decision, she actually gave time frame when she was referring to the period of time that the sexual offending was taking place. And in my brief, I point out that when you look at the application for complaint, it's definitely over a longer period of time. And
right, but we can't, I mean, that's not evidence, the application for the complaint.
It actually is. It was in the record, so it is evidence that the hearing examiner can consider. Any of those court records that are showing the dates of offense that are in the record, that he has been adjudicated a youthful offender on those with, and I point out in my brief, there is no amendment in the dates of offense that he has been adjudicated for. So that is something that a hearing examiner can certainly take into account, and it is something that
You're saying, like, assume hypothetically, I'm not saying this is this case, but assume hypothetically the application for the complaint says a 9-month period, but all the underlying reporting documents say a 4-month period. Can you still rely on the application?
Well, I think it's more than just the application. It's the application for complaint, it's the indictment, it's also the victim indicating that when he describes when he started to be victimized and when it stopped was when Mr. Doe started to leave the home for extracurricular activities, and that would have been in May or June of 2015.
How do we know that last part? Because that's the piece I could not find in the record, is when did the extracurriculars start?
I did not see it in the record. I did search for it as well. I did not see a specific date that indicates that, but what we would have to do is, in a hearing examiner, you would have to leave it to them to make a determination on that. And what you have is the hearing examiner pointing out the dates in brackets right around the time frame that the hearing examiner is describing as the sex offending period. So you can certainly look at all of the court records, and while you don't have a particular date, I did not see it, a particular date with regards to when he began, exactly when he began the extracurricular activities, the hearing examiner can certainly put that together with the other documentation that's in the record to make that determination.
So circling back to the Factor 2, Factor 37 issue for a minute, is there peer-reviewed literature to support the proposition that repeated sexual offenses are a predictive of future dangerousness?
I cannot speak to that, but what I would say is I don't see it in this record.
You what?
I do not see it in this particular record. And so where we're confined to the record, I can only go on what's before us. I'm certainly not aware of all the research that's out there, and a hearing examiner would not be unless that is put before them with regards to the evidence that is to be considered. Certainly in the evidence to be considered here, there is no articles that were submitted that negates that proposition.
So Doe argues that that Rule 23 decision got it wrong because part of it relies on Chapter 6, Section 178K, open paren 1, close paren, open paren B, close paren, open paren, I, close paren. So, which references criminal history but does not reference repeated sexual offenses. Is Doe right about that?
And again, I would point out what Justice Hershfang pointed out. In the court context, in the legal context, for example, the 58A hearing, in probation surrender hearings, in different hearings, you can take into consideration the repetitive conduct of a person. I do not see a distinction in a SORB administrative hearing where that is certainly accepted in the criminal context. There is nothing in case law that says a hearing examiner cannot take that into consideration.
So Doe argues that the hearing examiner made a mistake of law when she failed to consider current risk to reoffend and dangerousness. In other words, the hearing examiner relies on all these early factors, which is horrible crime. I really don't want to underestimate it. Absolutely terrible. And his immaturity, but then it's like, but the question is, what's the current risk? I mean, do you agree that the question is, what's the current risk?
It's always what is the current risk, right?
And so then you have all this terrible old stuff, and then everything after that is that there's, well, I mean, you can characterize it yourself, but what's the risk, what's the current risk?
Well, what I will always point out is all of the factors, regardless of the time, the passage of time, are specifically designated to determine one's current risk. And so then you have to look at the hearing examiner's decision and see that the factors that are being applied find support in the administrative record. Now, you could look at the hearing examiner's decision with regards to the mitigating factors that were applied in this particular case. And most of them got full credit because the hearing examiner is looking at what he is currently doing. And perhaps that is what brings his risk down from something higher to a moderate. The hearing examiner, when applying factor 13, for example, gives that minimal weight. So there is no indication in this record that the hearing examiner is arbitrarily applying any of the factors. There is no error in the application of any factor. All of them find support in the record.
Could you just address the internet publication? I'm not interested in the part about that there seems to be a frontal attack on internet publication.
Okay.
I think that's for the SJC and they've decided it. But what about in this case? Why is internet publication, I mean, first of all, I'm assuming that the mother is not running a daycare anymore with him living at home. So why is the internet publication necessary here?
Well, the hearing examiner points out that Doe has committed contact sexually violent offenses, sex offenses involving children, especially a non-consenting 12-year-old child, where he uses threats to kill, threats to cause harm to his bodily organs if he does not comply. And the hearing examiner points out that, of course, past this prologue, that's what the case law says, you have to look at what someone did before in determining what they may do in the future. And so here, while there is not a daycare, that is not to say he will not come into contact with children that may give him his trust, and the same thing may repeat. It does not necessarily have to be in a daycare setting. The idea is he is a dangerous person based on his, and his risk is moderate, based on his behavior, not necessarily on the place that he committed that offense. And when you look even at the setting that he committed it with other people present. So this is a person that did not stop him from continuing to sexually offend against this child.
I'm not, this is no indication of what I'm thinking, certainly not of what anyone else is thinking, but I'm just curious in this case where it came up to this court once and was remanded to the same examiner to fix what the court identified as deficiencies in the initial decision. If it were to be remanded again, would it go back to the same examiner again, or what is the process there?
I usually, it depends on what the court order is, honestly. I've seen court orders that send it back to the hearing examiner to readdress if they find that the hearing examiner has not addressed what they've sent back on remand. I've seen court orders that order them to do that, and I've also seen court orders that order someone else different if they find that there's a bias, but there is nothing in this particular case that shows that the hearing examiner is biased, so I do not see a reason to give it to someone else. For we just would be hearing examiner shopping.
Just to go back to the expert for a moment, the hearing examiner does, partly at least discredits the expert that Doe offers by saying that the underlying medical records were not submitted. Now, I know there's the piece where the hearing examiner is saying, well, would those records have corroborated his self-serving testimony? But let's leave that aside for the moment. If the hearing examiner had just said they didn't submit the underlying medical records, is that a proper ground to discard the expert's testimony?
But I don't think that was the whole ground. I think that was one piece of it.
I know, but that's what I'm trying to weigh, though. So if you couldn't rely on a piece of it, then is that enough to remand it? That's what I'm concerned about.
Well, I don't think that, because I think you have to, again, look at the whole entire picture of the person before you. And when you look at especially the expert testimony, the hearing examiner is very detailed with regards to what the hearing examiner what the expert did not consider that she considered and found aggravating towards his risk and his dangerousness. So there is sufficient grounds, even putting that aside, whether or not he had corroborating medical records to talk about his self-reports. I think that when you look at the hearing examiner's decision as well, you will see that she indicates that while he was in DYS, he was taking this same medication, and he had no acting out or any sort of behavior of that sort. And I do point out in my brief what the dosages were during that period of time. So I think the hearing examiner is in a position to make a discretionary finding with regards to that.
Thank you very much.
Thank you. Have nothing further.
Well argued by everybody. We'll take the case under submission. We'll take our morning break, and we'll hear our last two cases.
Thank you.
All rise.
Welcome back, everyone. We are hearing our fifth case on the list for this morning, 2023 P0686, Robert H. Strauten and another versus the Edgartown Planning Board and others. And on the appellee side, I believe you're splitting your time with Attorney Elder having 10 minutes and Attorney Grossman having 5. Is that right? Excellent. Okay.
Thank you, Your Honor. Members of the court, Paul Revere on behalf of Robert and Dana Strauten. This matter is a matter, it kind of brings you back to law school. Talk about the issue of res judicata. It's res judicata, and the question is whether a decision that the Strautens did not have standing under the Martha's Vineyard Commission Act serves to act under the issue preclusion arm of the concept of res judicata to prevent them from having standing on a zoning claim. And I think when I give the subject matter and explain it like that, while my brother and the court talks about issue preclusion, what they're really trying to do is they're trying to do claim preclusion here. My client had an action under the Martha's Vineyard Commission Act and has an action under an appeal of a decision under the Edgartown zoning bylaw. Those are two different claims. Now, I did not represent them in the trial court, so I don't know why there wasn't either a motion for consolidation or an interdepartmental transfer to bring the cases together. But the long and short of the answer is there was not. When you look at issue preclusion, there are essentially I'm going to sound like law school, 4 elements to prove. Go back to that. The first one is the same parties. Okay, well, there's one party missing, the Martha's Vineyard Commission, but we have the same parties. Okay? Was the matter litigated? Was it actually litigated? Well, we're going to get to the identity of issues because it was litigated, but the issue that was litigated was standing under the Martha's Vineyard Commission Act, not standing under 40A or the Edgartown zoning bylaw. Then you have to have the identical issue in both cases. And I think I just answered that question, that it's not the identical issue because we're talking about 2 different statutes. And then the court has to find that the decision was essential to the Martha's Vineyard Act decision. When we say identical, okay, what happened in this case is that the Martha's Vineyard Commission Act says that an aggrieved, I think it's party is the term, and Judge Wilson first concluded that, well, I'm going to find them to be a party because we're going to allow this to go broader than perhaps people that were literally in the proceeding before the Martha's Vineyard Commission. He then said, he first made a decision, and he said, I ruled that plaintiffs concerned about view from their parcel is beyond the scope of interests protected by the Martha's Vineyard Commission Act. So he first said, views are irrelevant to this. But he then went on and said, I'm going to decide if views are relevant, whether the plaintiffs in this case, Robert and Dana Strauten, have shown that they are injured in a way protected by the Martha's Vineyard Commission Act. He did it on-site, did various issues, and came to the conclusion that they weren't. Okay? So the first issue is there an identity of issues? I've said it briefly. When the court made this decision on standing, they were looking at the Martha's Vineyard Act versus the Edgartown bylaw. Now, when he looked at the factual issues on view, he applied the framework, and that's important to say, the framework of the Zoning Act. That is, under the Zoning Act, an abutter is presumed to have standing, and an abutter to an abutter within 300 feet is presumed to have standing. The court then, quote, a judge must...
When you say the Zoning Act, you mean Chapter 40? Or is it 40A?
40A.
Yeah.
Okay? When you use the framework, a judge must, quote, a judge must review the interest protected by the zoning bylaw and whether the plaintiff has put forth credible evidence of an injury protected by the bylaw. Okay? So that's the framework. And note, when I said the framework, you have to look at the interests of the bylaw. Judge Wilson was only looking at the interests of the Martha's Vineyard Commission Act. He wasn't looking at the bylaw. He was making a separate decision. I do a lot of land use permitting.
I'm sorry.
Okay, I thought you were interrupting. I'm sorry to interrupt. I do a lot of land use permitting. I have a project in Sandwich. It has 4 permits: a wetland permit, a variance from Title V, a Old Kings Highway historical permit, and a special permit. We're down to getting the special permit. Each one of those acts protects different things, different interests, okay? And standing under the Wetlands Protection Act is different than standing under the Zoning Act, because the Wetlands Protection Act protects wetlands. If you bring an appeal, you have to show how somehow the lack of protection of wetlands is going to injure your property's interest in wetlands.
So I think you're saying that the only way we could affirm is if we compare the 2 statutory schemes and conclude the interests are the same.
Right, but
And that we can't reach that conclusion.
I don't think you can reach that conclusion, because as Judge Wilson said, I find it doesn't protect views, period. Okay?
And you're saying the bylaw protects views.
Yeah, in fact, it's note 2, and I cut and pasted pieces from my brief, so I can't give you the page number because I cut it off the bottom. But I point out how the Edgartown zoning bylaw has multiple requirements addressing impacts on neighborhoods, requiring screening of neighboring properties. Screening, okay? Whereas it's clear from Judge Wilson's decision that you can see the tower from my client's property. Okay, it's a tower, you can see the tower. He just says it's not really that much to see. Instead, the Edgartown zoning bylaw, which is in the appendix and is set forth shortly in note 2, addresses screening, addresses visual impacts mitigated to the maximum extent possible. There are multiple view interests. When I quoted earlier about a judge must find the interest protected by the local bylaw, I was quoting from Monks v. Zoning Board of Appeals of Plymouth. The Monks case, it's an entertaining case because what I think the tower in that case is actually a half-mile away from the Monks' property, but the court found that they had established standing because the Plymouth bylaw protected views, okay? So I don't think that we can have the same issue here, because one is the Martha's Vineyard Commission Act and the other is the zoning bylaw. They're different. My brothers try to argue it's close enough. They're almost the same. They protect similar things, okay? But the point of the matter is they may be similar, but they're not the same.
So I hear you about the view impacts and how they're not the same. Your opposing counsel have argued that the claim about actually litigated and essential to the judgment, this piece, is relevant only to the view impact portion of the claim. Do you agree with that? Or maybe I'm misreading their brief.
I misunderstood your question here.
How about the other parts? Is it only on the view impact that you can draw this distinction between the bylaw and the Martha's Vineyard Act?
No. I mean, the Martha's Vineyard Act, it protects the look of the neighborhood, the impact on the rural character. As I say, I've listed those all out in note 2. But there are multiple things. And the fourth point of this, which is kind of related to, I thought, what you were asking, is to have claim preclusion. I'm going to run through them again. Sorry to take you back to law school. 1, same parties got that. 2, was it actually litigated? No question, ahead of trial. 3 is it identical? I say no. 4 is it essential to the judgment? Judge Wilson quote, "I rule the plaintiff's concern about view from the parcel is beyond the scope of interest protected by the Martha's Vineyard Commission Act." He's there. That's it. It's not essential to the judgment. He already decided it's not protected, period. So we don't have all four elements. You know, when I was reviewing this.
Isn't that a basis on which he denied standing? And doesn't that make it essential to the judgment? If it's beyond the scope, in other words, you have standing if you are asserting the violation of a right that is within the statute. He's concluding, I looked at the statute, this right is not within it.
Right. And that's exactly my argument, is it's views, according to Judge Wilson, views are not an interest in the Martha's Vineyard Commission Act, period. Okay? It's not complete dicta what he writes about views, but he applies this framework and says, well, even if they were, I'd come to this conclusion. Okay? But when you look at it, as I quoted from Monk, a judge must review the interests protected by the zoning bylaw and then see whether the person has put forth credible evidence. There's no review of the interests protected by the zoning bylaw. In fact, I talked to my client yesterday, because I'm actually going on a ski vacation in a week or so, and I was working this weekend, both days. And funny, they mentioned, you know, what was said in the transcript. And you could find this, the Martha's Vineyard Commission Act portion was appealed and upheld by this court. So you could find this deep in the appendices. But my brother said in his opening statement, quote, "This is not a zoning case, Your Honor." Quote, "The MVC is not a zoning body. Its statute does not charge it with analyzing or making assessments of zoning compliance, nor could they." Okay? And that's page 36 of that transcript on day one, if for some reason someone wants to chase it down. I think it's self-evident from the case that it's not a zoning case. But when I hear these arguments being made, it was very consistent, as my clients who are sitting over here brought out to me, that the trial was not about zoning. It was about the Martha's Vineyard Commission Act. And the Martha's Vineyard Commission Act is essentially, are the benefits greater than the detriments to the community as a whole? In fact, one of the things my client put to me when we were talking about this is, well, why would you need a zoning permit and a Martha's Vineyard Commission Act permit if they just protected the same things? They don't. They're different hands of different pieces that governments do.
So
my clients.
I'm looking at footnote 2, and there's a lot to unpack there. So what, you said, it's on page 15 of your brief, but you said you had it just excerpted. So what is it that you're trying to draw our attention to in this footnote?
Oh, well, there are multiple points to that, okay? In other words, it's clear that visual impacts are covered by the Edgartown zoning bylaw, just generally when you go across them. If you look at it, it talks about minimizing the extent of the requested dimensional waiver by judicious placement on the partial and judicious analysis of the necessary height. Then I'm quoting in there, like 23.3D, that the visual impacts of the proposed PWSF are mitigated to the extent practicable by such means as described in section 23.4, and then I go on to quoting 23.4, all construction shall be concealed, okay? That they are compatible with the architecture of Edgartown, such as flagpoles and light posts, okay? The planning board may permit, I'm reading farther down, may permit screening, camouflage, or terrain or existing vegetation to mitigate the impact. Design of the installations shall be traditional. My clients, when they look out of their cottage, look out their backyard, see a modern telecommunications device sitting there. And when I say backyard, I have my two clients here, okay? This is in a small little residential neighborhood on Chappaquiddick Island. I don't know if you know Edgartown at all, but it consists of this sort of beautiful downtown, and then there's an island that is famous in American history, sunk perhaps a presidential campaign. My clients aren't the rich and famous who live on Chappaquiddick. They live in the little center of the island. This is on a half-acre lot. They have an acre lot, on a major road across from the fire station. It's the David versus Goliath. I've got AT&T, I've got 2 law firms here. My clients have little old me from Cape Cod. I'm not that little old me, I do a lot of stuff. But the point is, all the powers but be in Edgartown have pushed to push this in this area. My clients have pushed back. My clients even have been, I won't get in, but subject to criminal complaints by the town against them, what I consider to be baseless. That's all. Thank you very much. Okay.
All right, then we'll hear from counsel from AT&T for 10 minutes.
Good, just about afternoon, Your Honors. I am John Elder from Anderson Krieger representing AT&T today. So a lot to unpack indeed. Standing is an issue. Without standing, you don't have a basis to proceed on a claim on the merits of your claim. Okay, so the harm that is being alleged by the plaintiffs is identical in both cases. It was identical between the MVC case and this case. The harm are 3 things: view impacts, safety of the tower, and real estate impact. All 3 of those issues were comprehensively evaluated by the MVC court, making extensive findings of fact with respect to each. As it relates to view, that included an in-person visit with discussion from the plaintiffs as to where they wanted the court to see the tower from. That's all in the record. There was testimony put forth by the plaintiffs regarding their views from different places on the property of the tower. Again,
Right,
the court.
but let's cut to it. He says we've got 2 statutes and there's a reason, or there's a bylaw and a statute. There's a reason why we have 2. They're different. If they weren't different, they'd just be the same. We wouldn't need 2.
They're not different with respect to standing, Your Honor, and the reason is that Judge Wilson explicitly applied the test for standing under zoning cases, under zoning appeals using 40A. He cited precedent from the Tisbury case, which said it was appropriate to do so for MVC cases. He used the test for standing under 40A and the Kenner and Standerwick line of cases. Okay?
He did. He used the same test, but he didn't use the same statute. So why doesn't that matter?
Because so the Edgartown bylaw is irrelevant because the only time you need to look at the statute is in the first instance to determine whether, generally speaking, it protects the harm that you are alleging is the basis for your standing. So the question is, with respect to views, for example, is there anything, Judge, in this case, had we not have an MVC case, okay, had this not happened, Judge Speicher would first look to the bylaw to say, in the first instance, is there any grounds here to support that your view of the tower from your property could form a basis for standing? That's a yes or no question. If it is, you then proceed to the traditional Kenner-Standerwick analysis as to whether the views actually rise to the level of special, particularized interest, right, that is different with regard to you than the rest of the community, so as to, quoting Kenner, paraphrasing Kenner, substantially adversely affect you. It must level to the rise of aggrievement. That is exactly what Judge Wilson did here. He cited that language. He weighed that consideration. So and to the extent that it's in the alternative, and we can talk about that in a minute, that should not matter either. But it's very clear, and plaintiffs don't dispute, they accepted all of our factual statements below in summary judgment, including our allegation that there was no difference between the interests forming the basis of their alleged harm, their standing, in the 2 cases. Okay, so nobody disputes that the evidence is the same. The MVC case was tried per agreement of the parties on discovery that was conducted in this case. Okay, they agreed it was sufficient to try that case. They put views of the tower front and center, first and foremost, in that trial. And the judge found in the alternative, and that said, the judge did say in the first instance, well, I find that, reading the language of the MVC Act, it doesn't protect views. However, Judge Wilson went on for several pages after that. Even if it did, let's take a look under Kenner and Standerwick and talk about whether or not your views from your property of that tower would actually satisfy the 40A test for standing, and concluded it does not. And he concluded comprehensively, as noted by a different panel of this court very approvingly in their footnote of their decision, how comprehensive that analysis in fact was. Again, so plaintiffs have already had the benefit of, in effect, a presumption that the interests they're putting forth as a basis for standing are in fact valid, right? Again, it's a threshold question. Is anything in the governing regulatory scheme, whether it's a bylaw or something else, support or protect the interests that you are asserting here? Yes or no question. Again, if it's yes, we proceed to the next analysis. That analysis has been done, Your Honors. And I would ask this panel, which I submit has not been articulated by the plaintiffs in their brief, has not been articulated today because it respectfully cannot be. What would be different about this trial? If this trial went forward on standing, what would be different? What would be litigated here in this case that has not been litigated and decided pursuant to comprehensive fact-finding in this case here? And respectfully, the answer is nothing. There is literally nothing else to look at. Because again,
Well, I presume he might say that there's a different standard, and I take it you say there's not.
There is not, Your Honor, because that question has been presumed. So it already has been presumed that view impacts are a protected interest, and it has then been analyzed. So it's beside the point. Judge Speicher could go ahead and I find that based on whatever language that plaintiffs are relying upon here, and by the way, I think it is worth pointing out that the language that they've cited actually talks about public views. And we know from well-established precedent in 40A zoning appeals that language in a regulatory scheme or bylaw or other governing regulation that talks about public views generally is not found to actually protect individual views in a way that would give you standing anyway. But let's just assume that they were. Again, we have assumed that they were. What they seem to be asking is for Judge Speicher to actually examine a bylaw so that the first initial question, whether views are protected, is a protected interest. But we don't need to do that. Judge Wilson already presumed that.
But was that presumption, was that conclusion essential?
Your Honor, it was essential. Because the definition of essential in the case law does not mean literally indispensable to the outcome. It really means the essence. Is it part of the essence of the litigation? And the Supreme Judicial Court case law going back to the 50s makes it clear that essential to the judgment means, did the parties in the court treat it as essential to their case? Did they put it front and center in their case? They absolutely did do it here. They put forth a lot of evidence. We had a view of the tower, in person. The parties spent, several witnesses and a lot of documents on this issue, and it was absolutely essential. And to the extent that it being an alternative, independent finding would somehow remove issue preclusion, at least to me, makes no sense. That would be every single case in which a judge found two alternative independent bases for an outcome, neither would be preclusive in any event, which is it's an outcome that to me doesn't make any sense just sort of jurisprudentially. It certainly doesn't make sense in the body of 48 standing law where, the policy is to avoid choking the courts with sort of frivolous, allegations of standing. So I don't think just because there are two alternative separately independent grounds for a ruling suddenly makes both of them inessential. That wouldn't make any sense. That would be contrary to the entire...
He's not saying they're both inessential. He's just saying the one you like is inessential.
Sure. But again, the definition of essential is not indispensable. It is whether it's part of the essence of the case, and it clearly was. It was put forward by the parties, it was vigorously litigated by the plaintiffs, vigorously litigated, and vigorously reviewed, vigorously scrutinized by Judge Wilson. And I think Judge Wilson's decision, I don't love saying speak for itself, as the famous line from, I don't know if it was Justice Holmes, who said, well, it speaks for itself, but what does it say? But I do think that Judge Wilson's decision in many ways does speak for itself in terms of how comprehensive it was, in terms of the evidence that was evaluated, in terms of where that evidence came from and how vigorously litigated this issue of views was.
Coming from a different perspective, what was the dispute in this case versus the other case?
So in this case, the dispute on the merits was whether or not the special permit for the tower was properly given under the bylaw. And I think since I have 46 seconds left, maybe this goes back to the citation to the bylaw, this laundry list of citations that, again, I would submit all go to public views and wouldn't help them anyway. But in any case, the issue isn't whether something has, the issue whether something has been properly screened. That may give you an affirmative answer to your general question whether views are protected, and then we'd proceed to the counter analysis that, again, has been done already here. Whether screening is properly found, that's a finding that the board has to make, as part of its decision. That goes to the merits of whether the board, abused its discretion in issuing its decision. You don't get to the merits until you establish standing. So you don't get standing based on every single nuanced regulation or criterion under the zoning bylaw that has to be followed on the merits. That's not where we get to standing. Standing is a basic threshold question. Is it protected? If yes, we evaluate it. Again, Your Honors, both of those things have been done. This case would be absolutely no different if we proceeded. That's exactly what issue preclusion and res judicata are meant to prevent.
All right, thank you very much.
Thank you.
We'll hear from Attorney Grossman.
Thank you, Your Honors. Please the court, Brian Grossman from Bowditch and Dewey on behalf of Robert Finbow, who is the underlying landowner. He's also the operator of MV Wi-Fi LLC, which is a wireless broadband provider that has had a tower on the property and provides wireless coverage or broadband coverage from the existing tower now. My brother has covered most of it. I think in terms of going back to the argued difference between the statutes, as Attorney Revere has classified it. Once you get past the step of, does this protect the view? Once you get to that, once Judge Wilson got to that step and said, I'm going to assume it does, that's where the difference between the MVC Act 40A and the Town of Edgartown zoning bylaw disappears. Once he goes beyond that step, once he says, I'm going to assume it does, he's no longer evaluating the MVC Act, he's no longer evaluating the bylaw. What he's saying is, under the standing cases, the Kenner-Standerwick cases that my brother has cited, would standing be conferred by the views? And as Mr. Elder said, we went through an extensive review of hours of testimony, several documents, including photographs, a site visit that visited all parts of the property that plaintiff's counsel wanted the judge to visit. And based on that review, judge found that the views could not confer standing, and that finding is not bylaw specific or MVC Act specific. It is, because they've already moved past that. They've assumed that is what they've already assumed that could possibly confer standing. Now the question is, okay, if we've assumed it does it? And that answer was no. And that answer doesn't change whether it's under the MVC Act or under the zoning bylaw. And frankly, appellants ignore the fact that they'd ask you to actually stop reading when they've said, and he quoted it twice during his argument, that I rule plaintiff's concern about the view from the parcel is beyond the scope of the interest protected by the MVC Act. Plaintiff's counsel or appellant's counsel hopes you stop reading there, and I know you didn't, because the very next paragraph says, even if view impacts could support standing here, that would not change the result.
Why is that not dicta?
It's not because of the same reason that the Attorney Elder went through as far as essential argument, which is this is not a throwaway line in dicta. This was the product of full litigation and of careful consideration, and he dedicated pages to why that decision and that line is accurate, why it wouldn't change the result. And then he goes through in several pages to explain, I did a site visit, we took a ton of testimony on it, I saw photographs on it. And that is why it is the product of full and careful consideration and litigation, and that is why, under the cases cited in the brief, that is why it is essential. And Judge Spicer recognized that as far as Fortier goes, because he says, the analysis of plaintiff's standing in the present case would be the exact same analysis as that conducted by the Superior Court, as the exact same legal standards and facts would apply. Because once you got past the question of could views confer standing, then the issue is you just review the framework under 40A as far as whether or not the view is sufficient or the adverse effect from the view is sufficient. And Judge Wilson, after all the testimony, the site visit, and the documentary evidence, in several pages, explained in a very thorough and careful analysis why the view, even if you assumed it could possibly confer standing, in this instant does not.
Thank you very much.
Thank you.
The case is submitted, and we'll hear our last case of today. 2023-P1176, L Group LLC and others versus UTICA National Insurance Group and others. So I know you weren't here this morning when I did our introductions, but we have read all of the materials, and so I would encourage you to jump in. We're usually a hot bench, and I know I have a lot of questions. So,
thank you, Your Honor. May it please the Court, Robert Taylor for the appellants. I'm going to briefly address three subjects. This case has been here before. We're back, and I think we're benefited by a well-reasoned decision from the last appeal. I want to touch briefly on the burden here, the insurance company's burden. I want to touch briefly on the insureds in this case, and then I'm going to cut to the chase and show you why it is this counterclaim and the other facts that were known to the insurance company clearly created a duty to defend. So first of all, what is the burden of proof here? Because of the prior decision, we know we're focused on exclusions. And so the burden is now on the insurance company, and it's quite a high burden. If you look at the language that's been used in other decisions in this court, any uncertainty as to whether or not there's a duty to defend, you rule in the insured's favor. And furthermore, the duty to defend is obviously much broader than the duty to indemnify. So again, at this point in the travel of this case, there's a very high standard on the insurance company. And it's also important to remember that what is the insurance company supposed to consider in determining whether or not there's a duty to defend? It's not only what's in the allegations of the complaint or the counterclaim in this case, but it's also other facts known to the insurance company. That's settled law. That's the Boston Symphony Orchestra case. It goes back to that case, and we've cited that case in our papers. So it's not enough for the insurance company to simply say, oh, I'm going to read through the complaint and that's all I'm going to do. If the insurance company has other facts and information that are available to it, it must consider those. And that makes sense because the insurance company does have a duty of good faith to its insureds.
and here by the complaint, you mean outside the counterclaims, right?
Again, in this case, it's a counterclaim. Yes, Your Honor. So, again, the standard is high, and the insurance company must consider facts outside of the counterclaim, and that's the Boston Symphony Orchestra case. Now, let me turn briefly to another important part of this appeal, and that is the issue of who are the insureds. Because in this case, there are actually, under the policies, 4 insureds. There's the lead insured, which is an LLC, and that's EL Group. But under the policy provisions, the policy expressly says that if you, as an insured, are an LLC or an entity, your members are also insureds. And we cited, that's policy section Roman number 2(1)(c).
And there are 3 of those, right?
There are 3 insureds. Now, my brother pointed out incorrectly, there are 3 members under the policy, It is the case that shortly after the counterclaim was filed, one of those members was dropped from the suit. So in terms of the coverage argument, there are 3 members, but I do agree with him that in terms of the actual parties to the underlying litigation, it's the LLC and two insurers. I also want to point out that there's more than one party on the plaintiff side, counterclaim plaintiff side also. And one of the interesting things is there's been a lot of talk about, oh, well, all this goes back to 2009 or 2010 or 2011. It's important to remember that one of the 2 plaintiffs here is Mr. Clegg's entity, and his counterclaim expressly says that that was not formed until 2012. So already the dates here are moving forward, and there's some ambiguity and a lot of unclarity about when there are allegations in the counterclaim about Mr. Clegg and his entity being impugned. Well, at least it's the entity, we know that couldn't have been any earlier than 2012 because that's specified in the complaint. That's counterclaim paragraph 10 is where that date is.
So on the exclusions, do you have to win every single argument to obtain coverage? In other words, if one exclusion applies, you're out, or you tell me?
No, I believe every exclusion is a separate contract provision, but none of those...
You have to win on each one of them.
None of those exclusions apply, Your Honor, and if you let me walk through, I can explain why.
That would be very helpful.
Okay. So I think the main one in my mind that certainly Justice Mulligan focused on was, well, there's a very specific allegation in the counterclaim about one of the insureds claiming that they were responsible for some of these designs. And Judge Mulligan essentially concluded that under exclusion C of the policy, because the counterclaim alleged there was this very specific kind of statement made, and that predated the breakup in the policy inception date. She concluded that the language of the counterclaim made it clear that really all that ever happened after that for the next 4 years while these businesses were going through this very messy divorce, that it was the same statement over and over again. And she concluded that because exclusion C does say, if it's the same statement over and over again, okay, that's going to be excluded. That's essentially, you can't shoehorn in coverage for something that started years ago. Fine. But when you look at the counterclaim, it's very clear that that's not the only statement that Mr. Clegg was alleging. And let me point you particularly, paragraph 68 of the counterclaim. And it starts out, as Judge Mulligan emphasized, it starts out talking about Joseph Lodeff, falsely represented to consumers and potential consumers that he designed or contributed to the design of Mr. Clegg's products. And I believe Judge Mulligan concluded that essentially that's all in terms of disparagement, that's all there was in this counterclaim. The problem with that conclusion is, just look at the very next sentence of this same...
I'm going to pause you right there. If that were the only sentence, do you agree one of these exclusions applies?
If the only disparagement was that Joseph Lodeff in 2011 had said what's alleged here, that would exclude as to Joseph Lodeff. But again, remember, we have Joseph Lodeff and EL Group, which, it's a separate corporation, so it doesn't necessarily get attributed to EL Group. Okay. And there's another Lodeff defendant. So as to Joseph Lodeff, yes. As to the other 2 insureds, absolutely not. But again, you don't even need to get there, Judge, because look, in the very next sentence of paragraph 68, after talking about this statement by Joseph Lodeff, it says, in addition, Joseph Lodeff has falsely represented in the industry that a backlog, a backlog of Lodeff and Clegg orders was due to the improper actions of the Clegg parties. Now, that's not claiming design origin in any way. That's a completely different type of allegation that somehow Mr. Loda allegedly was saying, oh, well, Clegg is responsible for improper actions. Well, that's disparagement. There's no question that's disparagement. It's not claiming design. It's not specified in here when or
But isn't
exactly
that
how.
intentional?
So you want to talk about that's a different exclusion. May I finish the?
Sure.
May I finish the exclusion C before I get to exclusion A, which is intentional? Thank you. So paragraph 68, again, in my view, it very clearly says, and again, we're on a duty to defend. This is not a duty to indemnify situation. And the burden is on the insurance company. And if there's any uncertainty, they've got a duty to figure it out. They can't just say, oh, no, sorry, we don't think that's going to be covered. Paragraph 68, and then if you look at paragraph 69, and I mentioned this in my brief, the last sentence of paragraph 69, again, it talks about the allegedly false claim of origin, so I see that. It talks about the EL group parties' production of knockoff designs and their false statements, indicating that they or their members of their team are responsible for these designs, and impugning the professional reputation. Now, I think there's at least two ways to read that sentence, because it says and. It's not clear that when he says and impugning the professional reputation, he's talking only about the claims of origin. It seems to me that he's talking about the improper actions that are also alleged separately in paragraph 68, and maybe other statements as well. It's and. You can't say with certainty that they're referring to the same single kind of claim of origin. And under the law, that's not enough to deny a duty to defend. Now, as I said, also the insurance company is obligated to consider other facts that are known to the insurance company. And we pointed out in our papers that in addition to the counterclaim, the insurance company did actually have other facts. And the other facts included excerpts from Mr. Clegg's deposition. And indeed, in Mr. Clegg's deposition, he gave testimony about, well, when you're talking about impugning in your counterclaim, what were you talking about? And he brings up a couple of different things, not just these false claims of origin. He talks about a posting on some website. That's at Record Appendix 310. And he's asked, well, were there other false statements made besides that posting? And the answer is yes. I mean, you know it's hearsay, but it originates from something.
Had they already made the decision at the time of this deposition, or did the deposition occurred before they made the decision to not cover?
So the initial decision to not cover was at the end of 2014. And then there were some follow-up requests to reconsider the decision. And there was a follow-up request in early 2017, which is actually also in the appendix. You can, I'm sorry, the response is in the appendix. It starts at Record Appendix 293. That's Mr. Solomon's response to this follow-up request for reconsideration, which attached this deposition testimony, which says, in my view, quite clearly that Mr. Clegg was alleging impugning generally, because at that point in time, the insurance company wasn't even conceding that he was alleging disparagement. We had to get through that. But it was also quite clear from this testimony that not only was it allegations of disparagement, but it went far beyond the limited allegation about claiming design responsibility. And just on that thought, again, at the bottom of page 313 of the Record Appendix, there's some testimony. And Mr. Clegg is saying, oh, are there other statements that you can point to? And he says, I'm sure there are. I may not be up on that. And then he tells a story about going to a trade show in New York where allegedly some of the Lotus were there. And he doesn't say that they were there claiming that they were the originators of designs. He says they were there and they tried to have us dragged out of the trade show. They claimed that we were bad-mouthing them, and we hadn't talked to anybody. And then he's asked, when could that have been? And he said, well, I'm not quite sure. It could have been, it was after the split. It could have been a year or two after. So here's the situation. We have Judge Mulligan saying, oh, well, the counterclaim only talks about claims of designing these bags. And yet we see from the counterclaim that's not the case. There's other things in here. And we see that from Mr. Clegg's deposition testimony. There are other things in here. And it only makes sense because, keep in mind what happened here. These were two groups, and they were in business together manufacturing these luxury leather bags and other kinds of leather goods. And then they broke up. They weren't getting along. In 2011, they broke up.
I'm sorry to interrupt you, but your time is fleeting, and you were going to get back to Justice Henry's question about A.
So let me talk about the intent. And so I have a couple of answers to that. Besides, there's three insureds here. So the allegations of intentional conduct, for one, I don't believe are going to apply to EL Group as the LLC, for one.
Well, why not? Why? I mean, how can it have liability that's not derivative of the liability of one of its principals, and why is it not the same assessment?
I'm sorry to interrupt.
No worries.
So so you have to imagine there's a counterclaim for disparagement, and it's against two individuals and the company. So assume for the purposes of argument that Joseph Lotif did make an intentional false statement. That's not necessarily going to be attributed to the LLC.
Because it's not within the scope and blah, 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 all of that analysis.
It would presumably be within, while he was working for the LLC, but the misconduct of the principal, I mean, the actions of the principal aren't automatically attributed to the corporation. It's just, the basic corporate law.
But if they're not attributed, then there wouldn't even be any liability of the corporation.
But so this is the problem. So here you have an insurance policy which insures you against claims for defamation. And to me that says, hey, somebody says I defamed them, and I say, no, I didn't. I go to my insurance company and say, I didn't do this. This is not what happened. And the insurance company says, well, okay. They've got to say, we'll defend you until such time as it's established that there's no duty to indemnify. Because otherwise...
duty to defend, right?
Well, I mean, in the first instance, because otherwise my insurance policy is worthless. Why do you buy an insurance policy against a defamation claim?
Take a simpler case. Let's assume an insurance policy covers EL Group for negligently driving a car, and but the allegation...
There's differences. So here, again, the policy specifically covers personal and advertising injury, which includes disparagement, which is an intentional tort. How can you have an insurance policy that gives meaningful coverage, including a defense, against claims that you intentionally slandered or libeled or disparaged someone, if right from the starting gate the insurance company can say, oh, well, the plaintiff here says that you intentionally libeled them, so see you later. That's a pretty meaningless insurance policy, I would say, because the whole reason you buy insurance is so that if you're sued by someone who is alleging that you defamed them, you're saying, no, I didn't. That's not what happened here at all. And you get a defense from your insurance company. The insurance company has to step in until such time as it can demonstrate that there was not intentional conduct.
I think we'll have to leave that there, and we'll hear now from the insurance company.
Thank you.
Thank you, Your Honors. May it please the Court, Sid Salomon with Millick and Porter
On behalf of the appellees, Utica Mutual Insurance Company, Utica National Group, Graphic Arts Mutual Insurance Company. Your Honors, the trial court in this case properly awarded summary judgment to the appellees based on 5 different exclusions, any one of which standing alone would have operated to exclude coverage for the narrow claim that was left following the first summary judgment and the first appeal, which was the issue of whether the counterclaim could be read as disparagement of Mr. Clegg and his business. And this is pertaining to the sentence that Mr. Taylor referred to for a backlog of orders and for the word impugn.
I want to ask you, before you move on, about 2 of the policy exclusions in particular, because as I read them, but I may be wrong about this, exclusions I and L are slightly different from the others, and is it your client's position that, and believe me, we haven't figured this out yet, but that if we were to determine that one or both of those exclusions applied, but not the others, that your client would still be completely relieved of the duty to defend?
To the extent that the coverage is sought for a claim under the insuring agreement on disparagement based on that conduct, then we would say that summary judgment would be properly granted simply based on those 2 exclusions. So just to look at them, one of them relates to the trademarking of the Lodif and Clegg mark, which Mr. Clegg contends was done without his consent. The other one relates to the formation of a website, frankclegg.com, which precluded Mr. Clegg from using the website and created confusion in the marketplace.
But then how would the exclusion on the bases of those, either of those claims, speak to Mr. Clegg's claims regarding, for example, the in-person bad-mouthing at the conference, or the what he claims was the claims that the designs that he says were his were actually made by your clients?
It wouldn't speak to that particular allegation, Your Honor. So there is really, you could group these exclusions, I would say, in 2 groups. The I and the L dealing with the trademarking issue, so the website, the mark of Lodif and Clegg. The other exclusions, the A, B, and C, going to the statements which form the basis of the disparagement allegations. And they attack those statements 3 different ways. But Your Honor is correct. It really is 2 different sets of exclusions, all of which the trial court properly found applied. But you're correct to the extent that the I and the L exclusion wouldn't go to the statements. It would go to the website and the trademarks.
And then practically speaking, what would happen? I mean, let's pretend for the moment that it's years ago and the trial hasn't happened yet, and that, that we're in the ex-ante position. Would Utica still be forced or be obligated to pay for defense with respect to some portion of the case?
Well, first off, if anything is covered, Utica's defending. But you have to look at what it is that forms the basis of the claim under the insuring agreement. So when you look at this claim, a number of things were originally alleged as falling within the personal and advertising insurance coverage. It was a defamation claim, a commercial disparagement claim, a trade dress violation claim, an advertising idea claim. So all of the ways that a claim could be considered as falling within the personal and advertising insurance coverage, those were initially part of this claim. As this claim went on and became a lawsuit in the Superior Court and eventually 2 appeals, it was narrowed down to disparagement. And from that, it was really narrowed down to what I referenced earlier, which is the narrow piece of it that caused this court to reverse in the first place. That being the word impugn Mr. Clegg's reputation, which we took issue as to what was impugning the reputation, and the comment about a backlog of orders. So it depends on really what's left. As this case developed, that is all that was left. So those are essentially the statements that we're dealing with. And I mean, now, it's a very narrow issue, having gone through the first appeal, through this appeal. It's really just these statements and these policy exclusions. So we can probably...
Could we start where he started, though, because I didn't see this addressed clearly in your brief, which is that the standard is about coverage is favorable to the insured, that, any uncertainty is construed in the insured's favor, and if you have other information besides the counterclaims, you have to consider it, right? You don't, there's no dispute about that, is there?
There's no dispute about that, Your Honor. So the information that was ascertainable to Utica was the counterclaim in the complaint, and then later it was excerpts of Mr. Clegg's deposition transcript.
Are we looking at two different decision points then?
Yes, to the extent that Utica is obligated to consider other evidence that becomes known to them. That would fall within the known or ascertainable. But I would suggest to Your Honors is that those excerpts from that deposition transcript don't really say what EL Group is arguing that it said. What they say in a fair reading of them is consistent with what is outlined throughout the counterclaim. And that's really one thing, and it starts with that first paragraph, which provides kind of a roadmap to the counterclaim and is repeated throughout. And that's that Mr. Clegg alleges that EL Group, Joseph and Frederick Lodiff, and very briefly Mr. Edmonds, entered into a relationship with him under false pretenses. And he alleges that they entered into this relationship with him.
He's alleging they were true scoundrels. They wanted to get his designs and his proprietary information, and then they wanted to set up competition, right?
Correct.
Taking the website frankclegg.com seems pretty bad for them. But this is where, though, I'm puzzled. So, they seem to be saying, they say definitely that the personal and advertising injury covered by the policy expressly include, well, do you think that excludes intentional torts? Is that the argument?
Oh, without question, Your Honor. It excludes intentional conduct.
So if the person is alleging somehow intentional torts but is somehow found liable for negligence, which I suppose could happen, do you have a duty then?
Well, I mean, it sounds like more of a general liability example that you're giving, Your Honor. This is looking at the personal and advertising injury, so
Yeah,
it's a different kind of insurance. And it's clear that the insurance isn't meant to cover intentional conduct that is done knowing that you're violating the rights of another, or making statements that are false.
And you say that because of exclusion A.
Well, I say that because of exclusion A, so that talks about personal advertising injury with knowledge that the act would violate the rights of another. I mean, certainly that is what's being alleged here, is that the EL Group parties are falsely taking credit for the design of Mr. Clegg's products and then selling knockoffs of them. That's what they allege, and Utica accepts those allegations as true in the counterclaim for the purpose of the coverage analysis. It's required to do that.
But he says, but my guy says, I didn't do that, and don't you have to consider that?
Not for purposes of the duty to defend, Your Honor, because the fact that the insured denies the allegations doesn't mean that the record is undeveloped for the purpose of a duty to defend. And we cited case law to that effect in our brief. The denial of the allegations does not create a factual issue as to whether the record is sufficiently developed to make the determination on duty to defend. With respect to this counterclaim in particular, the trial court found, and I think this court even observed the first time around, that it's It's an incredibly detailed counterclaim. It's 155 paragraphs, 14 counts. It sets forth a very clear chronology of events, particularly when viewed in connection with the complaint, which fills in some gaps as to the timeline as it goes. And it's interesting in that in deciding summary judgment based on the application of the policy exclusions, the trial court grouped the conduct into different timeframes. And these timeframes are extrapolated from the counterclaim and from
But what about where Mr. Clegg says, I don't know the time frame? What do we do with that?
Well, first off, with respect to the deposition testimony, I'd suggest that from reading that deposition testimony, it's not really saying what EL Group is claiming that it's saying with respect to that. But as to not knowing the time frame, the important thing to remember here, and the trial court observed, is that all of the conduct for which the exclusions apply, and we'll leave the website and the trademark part out of it, all predated the inception of the policy. So this policy incepts August of 2013. The comment that's attributed to Mr. Joe Lodiff at the trade show in New York occurs in February of 2011. That's the conduct where Mr. Clegg alleges he's taking credit for my designs, even though they're Mr. Clegg's designs. That allegation then gets repeated, but this is where the trial court landed on exclusion C, which, really, from our view, is dispositive of everything, because this pertains to injury arising out of oral or written publication in any manner of material whose first publication took place before the beginning of the policy period. That fits squarely with the course of continuing conduct that's alleged, and which the trial court recognized may have been happening, was that as time was going on, the EL Group parties were continuing, in Mr. Clegg's allegation, to take credit for his designs and to sell imitations of them.
So is C the easiest exclusion for you to win on?
I would submit it is, Your Honor, although I would also submit that even if we didn't have that, A and B, knowing violation of the rights of another or published with knowledge of its falsity, it's squarely alleged in the counterclaim. And it's stated that it's done by Mr. Joseph Lodiff, Frederick Lodiff, and this kind of dovetails into the differing insured's argument. The counterclaim actually defines the EL Group parties as EL Group, Joe Lodiff, and Fred Lodiff. At another place, it abbreviates the Lodiffs for Joe and Frederick Lodiff. Later, there's a count for conspiracy. Counterclaim...
But there is one claim that's just against, it's against EL Group, Joseph Lodiff, and the other Lodiff, but Frederick, and Edmonds, actually, but the allegation is it was just Joseph, and so they're saying, well, even if you don't have a duty to defend him, you have a duty to defend the others.
Well, what I'd say to that, Your Honor, is this is not a situation where there's some corporation that's not connected to the actors and is being held vicariously liable. EL Group is Joe Lodiff and Frederick Lodiff. They are the only actors to which this conduct is attributed, and it's clear from the counterclaim that this conduct is being attributed to both of them, and that they're doing it in furtherance of EL Group's goal of advancing its business by taking credit for these designs and for selling imitations of them. So it's very clear that these are actors acting within the scope of and for the benefit of the EL Group Corporation. There's no divergence as to that conduct. So it's very clear, and the counterclaim alleges, again, I would say in meticulous detail, that the EL Group parties
both of them are being, that the statements that form the basis of the disparagement, the lone piece that survived the first appeal, are attributed to both of them and to the EL group parties. And again, that's just how the counterclaim defines them.
All right. I think we'll have to leave it there. I think we understand your arguments, and the case is submitted. That concludes our sitting today. I want to thank our court officers and court staff for all their assistance in helping us with the sitting.